Right, good morning, everyone. Justice Bell, your camera is off.
So it is, thank you.
Thank you. Corrections, your camera is off. Thank you. I see Ms. Mulligan's device is still trying to connect, and Mr. Richardson is still trying to join. Let me just try to figure out what's going on with these two. Okay, Mr. Richardson was experiencing some technical difficulties, so he's left and will rejoin, and hopefully this time around we will get him in. Let's see. Perfect. Okay, good morning to everyone again. We are commencing the proceedings for Burgess and Rogers. The appearances are as before, and the proceedings are taken before my Lord President, Sir Christopher Clark, Justices of Appeal, Kay and Bell. Mr. Richardson, be left off with you.
Yes. Good morning. Can everyone hear me?
We can.
Thank you.
We look forward to hearing you say what you have to say about hearsay.
Yes, my lord. In actual fact, my lords, I mentioned yesterday that there was a passage in the case of Trevon Saltus,
Yes.
number 11. It should be in the electronic bundle. I have this morning uploaded the correct Trevon Saltus that deals with the jury pressure point. But the one that is in the bundle actually has a helpful extract that I'd like to share with their lordships before I move on. And the extract begins at paragraph 57. That's it. Mr. Cueto has it on the screen. And it begins, the learned judge then brought the jury in.
Give me a moment.
Sorry. Sorry, my
Thank
lords.
you. All right, I was going to the cloud and
Yeah,
Mr.
sorry.
Coelho.
I'll wait, my lord. My
No.
apologies.
No, I've got it on the screen, so that's
Okay,
good.
thank you. Before I actually read the passage, the point that I wish to round off here is that I submitted to you yesterday that in giving directions on the abuse point and the missing voicemail, on premeditation, and on what alternative views could have been taken of the evidence, it was our submission that those directions given by the learned judge should have been, and under the normal course, would need to be tied to the facts of the case to make it clear to a jury how they are to apply their minds to the evidence holistically and how they're to apply the law that they've been given. It's our general position that in this case, the judge didn't do that. And we'd like to share this passage from Trevon Saltus, one of this court's own decisions, to demonstrate what we say the specificity required is, and this court has recognized it. And it begins at paragraph 57. The learned judge then brought the jury in and gave them further directions. She reminded them of the elements of the offense of murder on which she had earlier directed them, and then turned to what she described as the fourth element, being concerned with others. True to the suggestion of Mr. Mahoney that she limit her directions essentially to those given before, she did not go on to the jury on the importance of analyzing Harris's evidence in the context of the alternative case. As Mr. Mahoney himself had suggested, she simply pointed out that from the nature of the case that the prosecution had run and Mr. Mahoney's address, the prosecution evidence was intended to cover two theories as to how Mr. Stubble was killed, and that it was appropriate for the jury to approach their task by considering four key issues as follows. The first is that Mr. Saltus was the shooter. So that's not, and you have no query about that. And they rely, of course, on all of the evidence. However, if you are not satisfied of everything that Mr. Harris has said, they also rely on the evidence of circumstances, including gang evidence that they say, when taken together, show that the defendant was one of the young men. And they are asking you to infer this, that the defendant was one of the young men that went toward the bus and encouraged the shooter to shoot Mr. Stubble. The judge then repeated verbatim section 27(1) of the criminal code, identified the elements of the secondary offense of aiding and abetting, and then directed the jury as follows. It is the prosecution's case that you can infer from the evidence that you do accept, very familiar language, that the defendant went up to the bus with those gang young men to encourage the shooter, that he did so with the intention to aid the unidentified shooter, that because of his gang membership in MOB, he knew the shooter had access to the MOB gun, that he knew that the shooter would use it to kill in a tit-for-tat shooting against Parkside member or associates. In this case, it was Lorenzo Stubble. I break here from the narrative of the summation again to note that no directions were given as to why the jury could or could not safely come to any of those conclusions on the state of the evidence and by reference to specific aspects of the evidence. And my lords, we make the point here that the summation in this case, and we shared large portions of it with you, did not in any way direct the jury as to how they could or could not come to the many competing conclusions that his lordship was putting before them. Even more troubling is the absence of any directions on why it would be safe for the jury to reach any of those findings if, as the words in emphasis predicate, they did not accept everything from Harris's evidence. And this is a case in which the jury were entitled to accept or reject the confession evidence, which we say was so highly prejudicial. While the finding of fact was the province of the jury, the circumstances of this case compel us to conclude that they called out for such directions from the judge. It did not suffice to leave the matter of comment on the important evidence only to the addresses from counsel. The same must be said with even greater force of the following directions on the law on aiding and abetting. And you'll recall, my lord, this is an aiding and abetting case with respect to Ms. Burgess. Where the prosecution alleges aiding by encouragement, such as from the presence of the person charged at the commission of the offense, such as by presence at the scene, and also that the person charged intended to encourage the commission of that offense by his or her presence. Voluntary and deliberate presence during the commission of a crime without opposition or real dissent may be evidence of willful encouragement or aiding. Now, in this case, my lords, you'll be well aware, the form of aiding that my client is supposed to have provided does not involve her being at the scene and actually doing anything physical in connection with the crime. While from an examination of the leading case law, it is seen that this direction taken by itself was not an incorrect formulation, it nonetheless behooves the learned trial judge to explain to the jury the evidence, if such she thought there was, which showed that the appellant intended by his voluntary and deliberate presence without opposition or real dissent to willfully encourage the shooter to kill Lorenzo Stubble, for instance, by the communication in some way of the intention to encourage. And we make the comment at this stage, my lord, that the directions on premeditation in this case were bereft of any explanation to the jury as to what evidence, if any, the judge thought there was, which supported that very vital element. He simply said, you have to find it. Look at the evidence. No attempt to specifically tie it to the evidence, to give the jury some practical guidance as to how they could seek to sift through the evidence and find that which he says they had to find, premeditation. They had no map. 63, as the Privy Council declared in Robinson, the commission of most criminal offenses, and certainly most offenses of violence, may be assisted by the forbidding presence of another as a backup and support. If D2's presence can properly be held to communicating to D1, expressly or by implication, that he is there to help in any way he can if the opportunity or need arises, capable of amounting to aiding and abetting within section 27(1)(b).
Court of Appeal, I don't think you're in the right room.
It is, however, important to make clear to juries that mere approval of, i.e. assent to or concurrence in the offense by a bystander who gives no assistance does not without more amount to aiding. It is potentially misleading to formulate aiding according to the second particular without that qualification and without explaining that the communication of willingness to give assistance is a minimum requirement. This simply was not done. Yet we consider that in all the circumstances of the case, notwithstanding the evidence of the appellant's connection to MOB, such directions were essential. In the formulation of any hypothesis of aiding and abetting because of presence, rather than himself being the shooter, the jury should have been directed to consider the possibility of the shooting having been a spontaneous action prompted by the mere presence of Lorenzo Stubble being found to be on MOB turf, and without the appellant having become a knowing participant, even if he was at the locale. And that is what I was attempting to impress on their lordships yesterday, that when it came to a charge of premeditated murder and the way in which the evidence in this case came out, there were various other scenarios which the judge had a duty to leave to the jury along with the proper direction. And if I could take you down now, my lords, to paragraph.
Before you, Mr. Richardson, could I just ask? I mean, I quite understand the point you're making,
Yes.
and I'm sorry to be pedantic, but which particular ground of appeal do you say it goes to?
My lord, we say that this goes to, if I had to spread, if I had to attach it to particular grounds, it would go to the abuse ground, in that the direction given by the judge on the abuse residue, as it would be, the missing voicemail, was not fulsome. It did not tie itself to the evidence that it should have. In particular, with respect to the no case submission, his lordship didn't direct himself properly on premeditation, because if he directed himself in the same way in which he directed the jury, key elements were left out. And the final ground that we do have included, in that the conviction is unsafe and unsatisfactory on all of the evidence, this particular case that I'm presenting to you is relevant to that, your overall assessment of the directions of the judge and whether they properly assisted the jury in the context of this case, and whether in that view, if that view is taken, the conviction can be said to be safe or satisfactory. If I could take you to paragraph 78 now, and that's the final paragraph in this case that I will take you to. And it begins, our concerns. And there were, generally speaking, I think this terminology can be applied, there was a general concern about the adequacy of the summing up on important issues in the case. And it's my submission to his lordships that in this case, there is a similar concern, which looms very large. And at paragraph 78, our concerns about the inadequacy of the summing up on important issues in this case can be aptly framed in terms of the dicta from the Privy Council in Von Stark versus the Queen. The function and responsibility of the judge is greater and more onerous than the function and responsibility of the counsel appearing for the prosecution and for the defense in the criminal trial. In particular, counsel for a defendant may choose to present his case to the jury in a way in which he considers best serves the interests of his client. The judge is required to put to the jury for their consideration in a fair and balanced manner the respective contentions which have been presented. But his responsibility does not end there. It is his responsibility not only to see that the trial is conducted with all due regard to the principle of fairness, but to place before the jury all the possible conclusions which may be open to them on the evidence which has presented in the trial, whether or not they have been canvassed by either parties in their submissions. And that's the key point. It is the duty of the judge to secure that the overall interests of justice are served in the resolution of the matter, and that the jury is enabled to reach a sound conclusion on the facts in light of a complete understanding of the law applicable to them. If the evidence is wholly incredible or so tenuous or uncertain that no reasonable jury could reasonably accept it, then of course the judge is entitled to put it aside. The threshold of credibility in this context is, as was recognized in Xavier versus the State, December 1998, a low one, and was also recognized in that case. It would only cause unnecessary confusion to leave to the jury a possibility which can be seen beyond reasonable doubt to be without substance. But if there is evidence on which a jury could reasonably come to a particular conclusion, then there can be few circumstances, if any, in which the judge has no duty to put the possibility before the jury. If there is evidence to support a compromise verdict, it is the duty of the judge to explain it to the jury and leave the choice to them. We say, my lords, that in this case, a premeditated murder case, where it was obvious that there was room for a conclusion to be drawn by this jury, that even if Ms. Burgess lured Mr. Gibbons to 10 Durant Lane, and we don't accept that that was proven, but even if that was proven, the jury would then have to be sure that the reason she lured him there was for him to be killed and no other reason. And the only evidence of that comes from the inadmissible evidence. It doesn't exist in her case. So let's put it out of our minds. So there was looming very large and obviously the possibility that if she had lured him there, she may not have lured him there to be killed. It may have been something else. It may have turned into something that eventually became. It may have became a killing, but may not have intended to be. And that was something the judge had a duty to put before the jury and to instruct them that if they found that that was the position, then they had to find her not guilty of premeditated murder. That simply wasn't done in this case. And that's the short point we make. It wasn't done with respect to any of the evidence. None of the possibilities were opened up. The jury weren't given any directions which tied the facts and evidence in this case to the legal principles that his lordship was pronouncing. I leave that case now, my lords, and I know my lord said he's interested to hear me on the hearsay, but I was going to ask their lordships if the next point I could address, because I don't believe the hearsay is going to take me very long, would be the jury pressure point.
Yes. I'm sorry, I was making rather a bad pun on words. Let's go to jury pressure.
All right. It begins at paragraph 148 of my submissions.
Yes.
And we begin by saying, my lord, that the jury in this case retired for deliberations at 10:16 a.m. on the 4th of March, 2020, and returned with their unanimous verdicts at 5:04 p.m., just under 7 hours of deliberation for a case involving some 54 witnesses, which spanned the course of some 7 weeks. It wasn't a short trial, my lords. There weren't just 1 or 2 witnesses. And on top of that, there were 2 whole cases to consider. The case of Mr. Rogers, and the case of Ms. Burgess. Now, I pause here by saying that they weren't assisted in this task by the way in which the 2 defendants' cases were conflated in the summing up. But the substantive basis of this ground of appeal, my lord, is 2-pronged. At first instance, we submit that the jury in this case was unduly prejudiced. pressure to reach a decision in this case on the basis that, having been warned by the learned trial judge to bring an overnight bag, if they did not reach a decision by the close of business on the day they were sent out to deliberate, they would essentially be put into a hotel. Now, the problem, my lords, that I essentially submit is problematic with that, is that, and I have no other way to put it, but it seems to rest between a rock and a hard place. On the one hand, the court doesn't have a legal power at this stage to allow a jury to separate. But on the other hand, the remedy chosen is one which, culturally speaking, most Bermudians would be considering akin to prison, especially in these modern days, to be locked up in a hotel, no cell phone, no ability to watch television, no newspapers, can't communicate with your family. That is not a pleasant experience. And just the forbidding idea that you may have to go through that would result, I say, in the minds of any ordinary Bermudian juror, to pressure. Because no one wants to stay in a hotel. Not in Bermuda. That's just not the way we see it. And I don't know if perhaps there's a cultural disconnect. But the idea, and I'm hoping Justice Bell can assist here, for the ordinary Bermudian of being stacked down Hamilton Princess in a budget room for the night with no communication is not attractive.
Mr. Richardson, what's the basis for saying that jurors weren't, for instance, allowed to watch television?
That is the usual practice. They're not allowed to communicate. They're not allowed to have any outside information, no television. Their cell phones are taken. They aren't allowed to even have newspapers. I was involved in the St. George's 7 case, which is the last case we remember, in which jurors were sequestered in a hotel overnight, and that was what was done. They were essentially stripped of anything except the amenities. And in fact, in one of the cases we're going to refer to, Justice Greaves was somewhat criticized for telling the jury the truth. That how bad it would be.
I mean, I think we all remember that, and
Yes.
Justice Attridge was careful to put the matter in the terms in which this court had expressed them in a subsequent judgment.
Yes, well, I think the crux of our point, Justice Bell, is this. We understand that the court may have felt constrained to develop some sort of practice, something to tell juries in order to ameliorate the unavoidable, i.e. that we can't let you separate. But what we say is that the remedy which was chosen was one that was counterproductive, and it does militate against a fair trial. What should have been done is that there should have been an amendment made which allows juries to separate. That suggestion should have been made. It's not this court's responsibility. But what this court found itself in, as with the previous courts, was a position where they couldn't allow the jury to separate, when in most other modern jurisdictions, this would have been a fait accompli, an application would have been made, the oath would have been administered, the jurors would have been allowed to go home for the night, come back the next day and properly consider the case.
I mean, your point is a general one, as I understand it, that in any case of significant duration and complexity, if the jury is told that if they don't reach a verdict within a day, they must be prepared to be hoteled, that equals, and then they do produce a verdict within a day, that equals pressure.
Yes, my lord, it is a general one, and it is quite succinct in that way.
So if they produced a verdict in an hour and a half, that would be undue pressure because they might have feared going on all day.
If they had produced a verdict in an hour and a half in a case that lasted 7 weeks with 54 witnesses, my lord, I would still have concerns. I would have concerns that both cases were not considered properly.
Well, I can understand that, but perhaps an hour and a half was an excessive example. But assume that they came back with a verdict at 2:30, having retired at 10.
I would still say, if they had already been told that had they not reached a verdict by the end of business that day, that there would be an inference there, that there would be some pressure exerted, at least some of them.
So the court is placed in this unhappy position that if it gives them warning in advance that they may be sequestered and they should bring some baggage in case that happens, that's undue pressure. And if the court doesn't tell them that, but at 4 o'clock in the afternoon says you've got to go to a hotel now, that's also undue pressure.
Well, my lord, there is actually, and perhaps we should go to it, there is actually, I still don't approve of the practice, but there is actually a mechanism that I think was a little overlooked that was pronounced in the other matter, which is Trevon Salter's number 11. I believe that's the one that's in the bundle. But what happens is that it appears, it's actually in the submissions, my lord. If I could take you to paragraph 155.
Yes.
Where there's an extract from Trevon Salters and the Queen, and it reads, in LaShaw and Simons versus the Queen, at paragraph 45, this court commented on the need for advanced planning in a case where the jury might need overnight accommodation and the need for the jurors to be alerted in advance to the possibility so that they can make arrangements to be away from home overnight should the need arise. No such advance warning appears to have been given by the judge in the present case. The danger is that if no advance warning is given, the judge is left with the dilemma. If he gives no warning before the jury has retired to consider its verdict, the jurors may feel under pressure to deliver a verdict because they have, for example, childcare commitments. If, on the other hand, he only tells them late in the day that if they cannot reach a verdict, they will have to go to a hotel overnight and continue their deliberations the next morning, that too is obviously unsatisfactory because they have not been given the opportunity to make the necessary arrangements to be away from home. There needs, in our judgment, to be a standard practice whereby jurors are routinely warned at the start of the trial that there is a risk that a problem may arise. They should then be warned more specifically when the time for their retirement approaches so that they can make any necessary arrangements in the case the need arises. My submission to my lords would be that if the court being left between the Scylla and the Charybdis with respect to being unable to allow juries to separate finds itself in this position, the time to tell jurors that you may end up being sequestered, and we can only imagine the plethora of things that people may have going on in their lives, which will not make it comfortable for them to remain overnight. So they should be told before they are impaneled, before they are actually seated as jurors, because they may wish to raise with the court very legitimate concerns as to why, if that transpires, they cannot stay overnight. But of course, if they aren't told at the beginning of the trial at that stage, and they're already impaneled, they're already under oath, halfway through the trial, let's say it's a 7-week trial, at the 3.5-week mark or 2 this, that's still insufficient because they can't back out at that stage. So that's the difficulty. And in this case, they were not told that before they were impaneled. They were told later on. And I appreciate that his lordship must have felt that he was in fact complying with the practice of this court. I guess what we're asking here, my lord, is for this court to now take a good look at that practice.
Remind me, if Mr. Richardson, what was the first time that the judge referred to the possibility of the jurors going to a hotel?
That is a difficulty that Ms. Mulligan and I discussed this morning before we came online. It is not in the summing up or the transcript on the occasions when the judge did that. It hasn't been transcribed. What we can all agree on is that it wasn't done before they were impaneled, and it wasn't done until we had heard a significant amount of evidence.
But it was done well before the summation.
It was done well before the summation, and then it was done again closer to the summation. But my lord, if you read the passage that we've just read, clearly what the court is saying is that it should be done at the start of the trial and then again closer to retirement to avoid the very difficulty that my lord just raised. That the judge be left with the dilemma.
I think we have a transcript of the time he said something shortly before the summation. But what you're telling us is that that was the second time he'd mentioned it. He'd mentioned it sometime between the commencement of the trial and the later stages of the trial.
Yes, my lord, but those mentions were very close to each other. It was as we were approaching the end of the trial, after we'd been there for several weeks, and it was clear that there was going to be some significant deliberations. But it definitely was not at the start of the trial, And no juror was given an opportunity to raise with the court any concerns that they might have, which might pressurize them because they have to operate in a jurisdiction where they can't go home at night. And most jurors, I think we can take it as a known, have no idea that it may result in an overnight stay from being on a jury, because for the rest of the trial, they're going home every night. So this is something that has to be made clear to them if we're to mitigate the unfairness at the outset, so that jurors can raise these issues. And alternates can be found, or they can be replaced by those who have no issues. But ultimately, my lords, the problem that arises is that in this jurisdiction, we aren't allowed, the judge doesn't have the discretion to allow the jury to separate. That's where the problem starts. If I could go back now.
In this case, there was an alternate who was put in at the last moment. Do you know why that was?
There was an alternate put in the last moment. I can't remember specifically why that alternate was put in.
It doesn't appear from the transcript.
No, it doesn't. That's why I asked the question.
Yeah.
Okay.
I'm not entirely certain why that alternate was put in, but I do know that it didn't have anything to do with the hotel issue. I don't believe that was the issue. Well, Lords, if I could take you back to paragraph 150, and I'm not going to take you through the cases that I've cited. They are there for reference primarily.
Just before you do that, is the first mention on the transcripts we have the one at page 277?
I have 277. At 277, I don't see him actually telling them that they may end up going to a hotel.
Well, it's implicit, isn't it?
No, my lord, what he's doing is giving them the general direction, but I don't think that's him telling them they're going to a hotel.
But he's referring back to what he said to them before in terms of preparing.
My lord, I have a note in my notebook that at the close of the case for Rogers, at 3:40 p.m., the judge advised the jury of
3:40, that time sounds familiar.
That was on the, don't have the date, no, but it was just at the close of Rogers' case on the 20th of February.
3:40 did sound familiar.
And the judge advised what, Mr. Mahoney?
The judge advised the jury of possibility of being sequestered. It was at 3:40 p.m. Rogers'
Do we
case
know which day that was?
Kevin Dodgenson.
I'm sorry?
This was on the 25th of February 2020.
On the when?
Yeah.
The 25th of February 2020.
So that's well over a week before they retired.
Yes, sir.
Do we know whether he said, if any of you have any problems with that, let me know?
I can't say, sir. I'd have to get the code smart and go through it.
Thank you.
I think it
That's helpful.
I think it would help if somebody were able to do that, Mr. Mahoney, someone from your chambers.
My colleague would ask Ms. King Dean to follow through, sir.
Thank you.
Appreciate that. And 3:40 did sound very familiar. But the point is this, my lords, unless that was said to this jury at the beginning of the proceedings before they were impaneled, raising an objection after they've heard several weeks of evidence, it wouldn't have happened. They couldn't, they were already locked in by then.
Well,
and I don't
they
believe,
were, unless they were excused.
well, I mean, to be excused at that stage of the trial, to stand up and say, oh, hold on a minute, I have a problem with a hotel. And my lord, let's be real. They wouldn't say that, oh, I have a problem with a hotel, if they had made up their minds, you know what? I'm going to reach a decision that day. I ain't going to a hotel. But we just don't know. And we can't exclude the very real possibility that that is what played out in the minds of one or more of these jurors. That's the danger. Had they been told at the beginning and raised no objection whatsoever, it'd be a more difficult inference to draw. But in this jurisdiction, jurors are routinely asked, do you have any difficulties with this? And our judges are very patient to listen to them and work with them to ensure they end up with a jury that is going to have, for better words, sustainability, that is going to make it the distance and isn't going to feel pressure. If that just simply wasn't done with respect, and maybe at that stage of the trial, forgive his lordship, he didn't envisage that we would be there that long. May not have envisaged that there would be an overnight sequestration, but it is something that did happen. And we say in the circumstances of this case, it worked, or at least the very real possibility is there that this jury felt pressured to reach a verdict so that they could go home. And I'm not sure how else to improve upon the ground of appeal other than that. My lord, see the comments that I've made at paragraphs 151. And that brings us back to another live issue, that both limbs of this ground of appeal rely on the affidavit sworn by Mr. Rogers' former counsel, Mark Daniels. In his affidavit, Mr. Daniels confirms that sometime between conviction and sentence, he had an accountant with the gentleman who was on the jury in this case. In sum, Mr. Daniels' affidavit exposes that a juror confided in him that they had effectively caved in to their fears that they would be sequestered and rendered guilty verdicts. Not because those were the true verdicts according to the evidence, but because the jury was under pressure to reach a verdict. We aren't yet aware of exactly how the court's inquiries into that have proceeded. But if any of that turns out to be remotely true, then that must amount to pressure and a repudiation of the oath. It has to. If there's even any risk that that is what transpired, this conviction should be overturned and she should at least get a retrial. Paragraph 152, we make the point that the court has a wide power to admit fresh evidence where it is necessary or expedient in the interests of justice to do so. And there's a test for fresh evidence, but my lords, there's another way to look at this. This may not necessarily need to be considered as fresh evidence. It is simply information which has been proffered in support of a valid ground of appeal. And as the lordships have done, you have decided how to regulate your inquiry into that. And we say there's no need for you to go through the tests for fresh evidence and the like. You can decide and regulate your own procedure as to how and to what extent you wish to pursue this information. And your lordships can decide how they wish to pursue it. And we've had that discussion, and myself and I believe Ms. Mulligan are in total agreement with the course that the court has proposed. So I'll leave that at that stage. I've shared the passage with Trevon Salters with you. At paragraph 156, we say, we humbly submit that the injustice which this court, in the case of Trevon Salters, has set out to prevent is, with respect, exacerbated by the instructed direction to alert the jury that they need to make arrangements to be prepared to be sequestered in a hotel overnight if they fail to reach a decision, has the effect of putting pressure on a jury to reach a verdict so as to avoid having to endure the undesirable circumstances associated with being sequestered. In paragraph 157, we make reference to the case of Dauphin, which is in the bundle. At paragraph 160, we make reference to the case of Mitchell, which is also in the bundle. At 161, we cite the case of Defoe versus the state, which makes the point, which I think we have to rely on in this case, that on occasion the seeds of pressure may arise without direct judicial intervention at all. The seeds of pressure can simply arise from circumstances, my lord. And there's a combination here of judicial intervention, which the judge felt he had to do. What we say is, if he felt he had to do that because he was constrained by authority, he should have followed the authority and done it at the start of the trial. He didn't do that.
Sorry, when you say at the start of the trial, do you mean in the process of impaneling of the jury?
Yes, my lord. That would be the only logical, sensible place to do it, so that you can then identify those jurors who may not be able to stay true to their oath if faced with that particular possibility. It makes the only logical sense. We ask them at the beginning of the trial whether they know any of the witnesses. We ask them if they have any health problems, all for the same reasons, to ensure that we have a jury who can remain focused on its task and discharge its oath without distraction.
You ask them, have you any difficulty, if necessary, in staying overnight when you have to reach your verdict?
If it reaches that, would you have any difficulty in staying overnight? Would be a simple question. And judges do it all the time. Jurors would say why. Some jurors might have medical difficulties, which they can easily accommodate going home overnight. But then being faced in the middle of the trial with, oh my God, they may not raise it. They may simply say, well, guess what? I'm not going in. I know what I'm doing.
But is that regularly done now? I mean, this court is handing down judgment later this session in a case which is involved scrutinizing the selection of jurors in a number of different, 3 different cases. And I don't recollect that in any of them, although the jurors put forward a number of reasons why they shouldn't serve or excuses, I don't recall that in any of them, any juror said or was asked whether they would have any difficulty in relation to staying overnight.
Yes, my lord, you're correct. That's because routinely judges find themselves in a very difficult position. Some judges would take the view, most judges would take the view, but unless you read this court's previous ruling very carefully and understand why they say to do it at the start of the trial, most judges would take the view that they don't want to mention it unless it becomes a realistic possibility, because just mentioning it may be pressure. That makes the point. So if you have to mention it, which they have to, you should be done at the beginning. Do you have any health difficulties which would make it difficult for you to sit late into the day or to stay overnight? Do you have any other child? Are you a single parent? These are things that are canvassed routinely with jurors at the beginning of trials.
Yeah.
This issue isn't, because it doesn't arise that often, my lord. I must say, not often does a jury have to be sequestered, but in the instance where they do have to be sequestered, the practice should be followed. Because as we say in our submission, I don't waver from it. First and foremost, the criminal code, in that it doesn't allow for jurors to, is unconstitutional. It's unfair. It's archaic, and it's out of step with the rest of the modern legal world. But more specifically in this case, the judge finding himself in that position, the failure to say it to them at the beginning of the trial, amongst all the other difficulties that they were allowed to pronounce. And my lords, I don't think we need to, a number of jurors were excused or stood by in this case for all sorts of personal difficulties, spanning a myriad of reasons. All of them, of course, grounded in the principle, can we get a jury that's going to last the duration of this trial and is going to be able to stay focused and discharge their oath? In these circumstances, my lord, and again, I repeat it, we say it's unconstitutional, but if it has to be, then it is vital. It is almost an indispensable condition that you say it to the jury at the beginning, the entire panel, so that when you select that jury, there can be less argument that anyone was under pressure, because they knew before they took their oath and took their seat that that might happen.
I can remember cases where sequestration isn't the norm, where nothing was said at the start of the case, and nobody would have contemplated at the start of the case that sequestration would eventuate. But because of something that happens during and sometimes at a late stage of the trial, the judge decides that the jury should be effectively sequestered. It's usually to do with jury nobbling and that sort of thing.
Mm-hmm.
Now, in England, the logical implication of what you're submitting is that the judge in every case, even though sequestration is extremely unlikely, should tell the jury that it's nevertheless a possibility for which they must be prepared.
Well, my lords, I think,
even though there's a, I don't know, 1 in 10,000 likelihood of it actually happening, because if he doesn't, it will vitiate the safety of the verdict in the one case where it does happen.
well, my lord, the difference, I would say, the distinction is this. that in your jurisdiction, a judge always has a choice, a discretion rather, to sequester, and that discretion is exercised, as you said, very exceptionally, and everyone would know that. However, in Bermuda, a judge in a case where the jury do not decide by the close of day inevitably has no choice, and that's the difference.
The fact that you are submitting that this is suspicious on the face of it, because it was a long, complicated case with two defendants, and they took all day to reach, only one day to reach a verdict, is not really borne out by the fact that you're also telling us that sequestration is rarely necessary in Bermuda.
Yes, my lord. Sequestration is rarely necessary in Bermuda, but in cases which go on for weeks and weeks and weeks, it has actually happened. I don't know, I haven't been involved in trial, but this was one of the longest that I've done, 7 weeks.
Yeah.
What was the date, Mr. Richardson? Mr. Richardson, what was the date of the St. George's case where you said there was sequestration? How many years ago was that?
No, I'm not entirely certain.
I remember the case, but it's a fair while back, isn't it?
Not that long. I've only been practicing for 15 years, and have been practicing for some time then, so it wasn't that long ago, my lord.
10 years or so?
Probably about 10 years or so. And in that case, what happened was that there were, I think, 7 defendants. They actually delivered verdicts in respect of 5 late in the day, and they were hung up on 2. And eventually they still didn't decide on those 2. I think they remained.
This was the fray over cup match, was it?
Yes, down near my lord's Bay Lane, my lord.
Yeah.
That was the last time I remember a jury being sequestered.
My lord, it was in May 2010.
2010, there we go.
Right. Well, no doubt Mr. Mahoney can speak in due course as to his experience.
Yes, my lord. My lords, if I could pick up the submissions. Actually, on this point, my lords, I'm going to say that the submissions actually and the cases speak for themselves. I don't need to take you through them. The essential point has been made. What remains for me to do now is to address you on the hearsay point.
Yes.
And that will be found at paragraph 133 of the submissions. And it is a very short point, my lords, which doesn't need to be belabored. My lords will be well aware, and we all know this, that the confession of one co-defendant is inadmissible against another. We would also all be aware that there is a discretion in a trial judge when faced in a case where one defendant has made a confession implicating another to mitigate the prejudice caused to that defendant by redacting or editing the confession to remove named references to the co-defendant. Now, I've included in the bundle when I uploaded it an extract from articles which cites the case of Silcott. The principle is not in dispute. I think what the lordships may have an issue with is why didn't I ask for that to be done at the trial, at the time. And I have to be candid and say that when Mr. Griffiths read the record and alerted me to that mechanism, I have to take fault for the fact that yes, I could have raised that mechanism at that time. But that doesn't dispose of the matter, my lords, because it's my position that having considered the case of Hayter, which I took you to yesterday and which was before his lordship, that mechanism was in fact squarely before the court. And it could have and should have and would have mitigated the unfairness. So our simple point is this, that we do not resolve from the submission that the confession evidence of Mr. Rogers was highly prejudicial to Ms. Burgess. And for that reason, we asked earlier on for severance. And we think these trials should have been had separately. But the trials having not been had separately, it was the trial judge's duty, and it wasn't just to be left to the advocates, to ensure that any prejudice against the co-defendant, Ms. Burgess, was properly mitigated. And as we submit in our submissions on this ground, there would have been no difficulty or danger in simply removing the references to Ms. Burgess and allowing the references to Mr. Rogers to go through. And I'll just quickly read that section of the submissions, my lord.
Well, in the case against Rogers, the prosecution would need to establish how it came about that he did what he was alleged to have done. Otherwise, it would just be a random shooting. And that's inevitably going to include the parts of the confession admissible against him that describe how the witness said it came about.
Well, that would be in the case against Mr. Rogers, but what we're dealing with is the inverse, in that that information was totally inadmissible against my client.
Well, I understand. It seems to me that, of course, if you win on severance, you don't need this.
No.
But if you don't win on severance, then it was inevitable that the jury were going to hear at least parts of Ms. Card's evidence, which referred to your client as being the explanation as to how and why Rogers, according to Card, came to do what he did.
Yes, that would be a difficulty the Crown would be faced with, but that difficulty has to fall in the face of the rules of admissibility. I understand the Crown would have had a difficulty completing the story either way, and that's why I call it the tangle that cannot be untangled. It's wasted fishing line at this point, cut it out. That's why it can't be untangled, because the Crown couldn't complete their story, their theory, their narrative, as it were, against either defendant without reference to the material that was inadmissible against my client, and that's the problem.
But aren't you saying there that, Mr. Richardson, aren't you saying there that it could not be the confession that Mr. Rogers is said to have given to Card could not be redacted appropriately?
No, I'm not saying it couldn't have been redacted appropriately. I'm answering my Lord's inquiry that if put in as it was, it would have involved those references that he has rightly identified. What I'm now going to go a step further and say is if it had been redacted, my Lord is saying it may not have made as much sense. But that is a difficulty the Crown would have had to live with, because fairness of the trial is more paramount than completing the Crown's narrative. And it almost seems that that's what was done here. Well, the Crown's story is not complete without this. But the rules of fairness and admissibility, those come first. And if you can't complete your story or your narrative because you're smack dab up against one of those rules, as one of the cases says, then that leads you up the gum tree, doesn't it? But that's not the law's problem, to put it quite bluntly. And that's the difficulty we have here. And that is why this case, I thought it cried out at the beginning for severance, because I knew there was no way conceptually, the way the cases were being run, that you were going to be able to separate that golden thread of prejudice which ran between the two, unless they were tried separate. I would just quickly pick up at 134, putting the point that the learned trial judge ought to have ordered separate trials to one side. He nevertheless had a duty to remove from the jury all evidence that was inadmissible against Ms. Burgess, that would unduly and adversely affect the fairness of the proceedings so far as it concerned Ms. Burgess. And that power, of course, exists, as we set out at 135 under Section 93(1) of PACE. Paragraph 136, Katrina Card was a key prosecution witness in respect of the case against Cleveland Rogers. In sum, her evidence was such that Mr. Rogers had confessed to her that he had killed the deceased for his half-sister, Ms. Burgess, in exchange for a payment of $5,000. Ms. Card's evidence put the following inadmissible matters before the jury. One, that Mr. Rogers confessed that he had killed Trina's boyfriend. That reference could have been edited out. Yes, it would have hurt the Crown's ability to make a sensible case against Mr. Rogers, but it certainly should have been done in order to do justice to Ms. Burgess. Two, that Mr. Rogers confessed that he killed the deceased in exchange for payment from the appellant Burgess. Yes, we accept that redacting that part, that it came from the appellant Burgess, does hurt the sensibility of the Crown's case in a joint trial. And that's the point. It hurts if it's a joint trial. Had this been a separate trial, the prosecution would have been free to leave this evidence ad nauseum against Mr. Rogers without any edits or redactions, and they would have been able to run a case against Ms. Burgess if he was convicted, which also made no reference to this material. That would have been justice in this case. And whatever the results would have been, we could have lived with it. But looking back on what happened here now, clearly something has gone wrong. 3, that the appellant Burgess had visited the residence she shared with Mr. Rogers. And after her, the appellant Burgess visits, she saw Mr. Rogers with sums of cash. And he, Mr. Rogers, told her that the appellant Burgess always paid her in cash, when in fact, she didn't see who came to bring any money. That's total hearsay. Simply, Mr. Rogers told her, hey, somebody just came to bring me some money. It was so-and-so. She never even saw the person. D, that she actually never did actually see the appellant Burgess come in or to the yard, and that her recollection of the appellant Burgess was based on what Mr. Rogers had told her. E, that Mr. Rogers used to call the appellant Burgess for money in relation to payment for the murder, and that Mr. Rogers had told her that he had told the appellant Burgess that the payments were for all jobs, although she, Ms. Card, knew based on Mr. Rogers' confession that the money was for the murder. We say that those 1, 2, 3, 4, 5 items were so highly prejudicial, they should have been edited or redacted, and the rest of it could have gone in against Mr. Rogers. But it was totally unfair to leave that material to go against Ms. Burgess in a trial where you've already decided, or it has already been decided, that there will be no severance. At paragraph 138, we say, my lord, at line 18, I believe, on 356 of the learned trial judge's summation, he directed the jury that Ms. Card's evidence was inadmissible against Ms. Burgess, notwithstanding that he had just moments prior given the jury a summary of Ms. Card's evidence that made it admissible in the highly prejudicial references to Ms. Burgess by name. I could just take you to that page. Come back over. And it begins, I guess we could start at 354. Line 9. And the prosecution says to you, ladies and gentlemen, can it really be just a coincidence that this woman, Ms. Card, who's never been there before, that Mr. Rogers told, says that Mr. Rogers told her that he hid behind the couch, and lo and behold, here in the photographs is a couch right there, around the corner from the front door to the apartment. Of course, the defense says, just look at the photographs of the couch and the plant and the telescope behind it. How could anyone hide behind that couch with those behind there? Ladies and gentlemen, you again are triers of the fact and respect of this matter. And that is just one of the many matters you will have to consider and determine this case. Ms. Card said that Mr. Rogers never used Marcus Gibbons' name when describing the details, but referred to the guy. She told you that Mr. Rogers said that the guy, meaning Marcus, was saying, tell me what I've done, as Mr. Rogers killed him. Sometimes she said that Mr. Rogers used to brag about it. She said he used to hang around the Boulevard guys, and Mr. Rogers would say, Boulevard guys don't even know they're hanging around the killer. Ms. Card also said that when she and Mr. Rogers would get into arguments, he would say, I've already got blood on my hands, girl. I've already got blood on my hands. She said that she was very fearful of Mr. Rogers. She said that Mr. Rogers also told her in respect to the murder of Marcus Gibbons that he got him from behind, but she said that he never said how he killed her or what he used. Ms. Card said prior to the murder, Ms. Burgess did not come across the lane. The relationship with Ms. Burgess was not a close one. She said, but after the murder, she told you that Ms. Burgess did come to the apartment at 9 Croston Lane to see Cleveland. He was there when she came, according to Ms. Card, and she knew he was coming. Ms. Card said that this was a month or two after the murder. You'll recall, however, that Ms. Card told you that she remained inside the studio apartment, having said that she was on the bed watching TV, and she never actually saw Ms. Burgess come to the yard or in the yard. Mr. Rogers simply told her that Ms. Burgess was there and that he had met with Ms. Burgess in the yard. Fascinating. Ms. Card said that when Mr. Rogers came back inside, he had $500, which he showed her. And Ms. Card added later that, according to Mr. Rogers, Ms. Burgess always paid him in cash and that Mr. Rogers would show her the money. You will remember my direction to you, and this is the point, however, ladies and gentlemen of the jury, which you must accept, And that is that, as a matter of law, this is no evidence against Ms. Burgess, and you must not consider this evidence when you come to deliberate upon the case against Ms. Burgess. It is, as you have seen from the further and better particulars of the prosecution's case against Ms. Burgess, no part of their case against Ms. Burgess, that she paid Mr. Rogers to commit this offense. And I must direct you that as a matter of law, there is no evidence against Ms. Burgess that she did pay Mr. Rogers. This evidence is evidence that you may only take into account when you come to consider the case against Mr. Rogers. It is not evidence that you can take into account when you consider the case against Ms. Burgess. And there's the tangle, my lord. The tangle that could have been completely avoided if we had removed references to Ms. Burgess. But partially avoided, I should say. But that type of direction to the jury, it was almost impossible for them to separate the cases. And constantly, in his efforts to remind them not to include the confession evidence when considering Ms. Burgess's case, he had to remind them about the confession evidence. It was a tangle that couldn't be untangled. At paragraph 140, my lords, they say Danielle Foley was another key prosecution witness for the case against Stephen Rogers. In sum, her evidence was such that Mr. Rogers had confessed to killing the deceased at the request of Ms. Burgess. In sum, the evidence given by Danielle Foley placed the following inadmissible statements before the jury. A, that Mr. Rogers had told her, Ms. Foley, that the deceased was stalking his half-sister, Ms. Burgess, and that she, Ms. Burgess, asked him, Mr. Rogers, to murder the deceased. The references by both Ms. Card and Ms. Foley were inadmissible against Ms. Burgess and were not at all required, we say, for the jury to glean the thrust of their evidence against Mr. Rogers, which was essentially that he had confessed to killing Marcus Gibbons. In the circumstances, the learned judge had a duty, prior to both witnesses giving evidence, to order that the inadmissible hearsay evidence that referenced the appellant Burgess be redacted from their evidence, and the learned trial judge should have directed the witnesses to refrain from making reference to Ms. Burgess. Now, we recognize that the prosecution will assert that the evidence was important background evidence that was required in order for the jury to have a full picture, and I think I've made this point to you, of the confession. And whilst we vigorously disagree that it was necessary for that reason, my lords, if the learned trial judge shared that view, that the evidence was important background evidence, despite its inadmissibility and highly prejudicial effect on Ms. Burgess, this was all the more reason for the learned trial judge to sever the cases and order separate trials. Because he didn't do so, he had an obligation to remove the inadmissible and highly prejudicial evidence from the jury to maintain the fairness of the proceedings. A plethora of evidence was put before the jury that was highly prejudicial to Ms. Burgess, notwithstanding that the evidence was inadmissible against her. I think we can all agree with that. The learned judge's directions to the jury, we say, could not and did not in this case cure or sufficiently mitigate the dangerous prejudice that was caused to Ms. Burgess. The learned judge ought to have exercised the statutory discretion afforded to him by Pace to redact those references which related to Ms. Burgess from the conviction evidence. And his failure to do so, my lord, compounded a miscarriage of justice. In closing out this ground of appeal, my lord, it's important to highlight that the prejudice suffered by Ms. Burgess as a result of the trial judge's failure to exclude the inadmissible confession evidence insofar as it referenced her is evidenced by the learned trial judge's ad nauseum references to motive and the confession evidence of Ms. Card and Ms. Foley, particularly as it relates to their references of Ms. Burgess. Taken together, my lords, the learned trial judge repeated references during his summation to evidence that was irrelevant for the jury to consider in order to convict Mr. Rogers and inadmissible against Ms. Burgess cumulatively resulted in a grave injustice. As I pointed out to you, the more he mentioned it, the more he livened it up and couldn't avoid mentioning it because it was so important to complete the case against Burgess. And there's the tangle, which can't be undone.
Quite difficult to adduce Ms. Card's evidence without any reference to Burgess. I'm just thinking about it. There she is in the witness box in chief. And I suppose she can be asked, did Mr. Rogers tell you anything which related to what happened to Marcus? But just before you answer that question, you should understand, I don't want you to make any reference to Miss Burgess. And the mechanics of adducing that evidence viva voce seems somewhat tortuous.
Yes, my lord, I agree. And the fact that that is the position that is the only position we say which would have preserved fairness for Ms. Burgess, dictates that the trial should have been held separately.
Yes, well, you say that's tough on the prosecution, but they could solve that by having separate trials.
Yes,
That's what you say.
that's what I say, my lord.
Yeah.
If the difficulty was that insurmountable in separating the cases, then there shouldn't have been a joint trial to begin with.
Right.
My lord,
Could you just help me before we leave this? If you look at 137E in your list of inadmissible evidence,
137, yes, my lord.
137E of your submissions, I've got slightly lost as to who was saying what to whom.
Yes, sorry, my lord.
Item,
137.
no, it's
Yeah,
me, not you. Mr. Rogers used to call Burgess for money in relation to payment for the murder. And she said that Rogers had told her, that's Miss Card, presumably,
yes, yes,
that he had told Burgess
yes.
that the payments were for odd jobs, although she knew based on his confession that the money was for murder. I didn't quite understand.
I'll explain to you, my lords, and you, it comes clear when you review, and I'm sure Miss Mulligan would do that, Miss Card's evidence, and I think her transcript is there. What was being explained was that Miss Card was saying she knows that Miss Burgess used to give Mr. Rogers money. And what she was saying here is that he had told her that Miss
He had
Burgess,
told her who?
well, in other words, it was, okay,
Doesn't it make more sense if we substitute?
it's best to read it. I think we're going to have to read it.
Yeah.
And doesn't it make more sense if we substitute Miss Card for the appellant Burgess?
Yes, it does.
Yeah.
Yes, it does. That's essentially what I was trying to explain. Right. So he was trying to, Miss Card was trying to say that Clevie was trying to tell me the money was for all jobs, but I knew it was for the murder. That's essentially what she was trying to say. But all of that, totally inadmissible hearsay against my client. It's almost double hearsay. But in any event, my lords, I believe that I've addressed you on all of the grounds that I intend to put before you, unless I can be of assistance.
Thank you very much indeed. Well, subject to any questions that my colleagues may have, I think we should take.
None so far as I'm concerned.
No, thank you.
Yeah, well, I think we should take, be convenient to take a short break now. We'll have a 10-minute break.
Turn at 10:20, my lord.
Yes.
Thank you.
Justice Bell, could you hit the court mark?
Exactly.
Thank you.
We all assembled, I think we are. Mr. Richardson? Mr. Richardson? Mr. Richardson?
Yes, my lord. Sorry, I was muted.
Sorry. You are. Before we hear from Ms. Mulligan, there is one matter that slightly concerns us. In the course of your submissions, you have in effect said that, as one of the many points, that what the learned judge ought to have done, if the case got that far, was to ensure that in his summing up, in a separate compartment and not mixed with the case against Mr. Rogers, there was set out the evidence against Miss Burgess and what that evidence could lead the jury to conclude. I'm expressing that rather badly, but that's in essence what you were submitting. It doesn't seem to us self-evident that that falls with any ease into any of your specific grounds of appeal. Your grounds of appeal, for understandable reasons, run into each other. But we think that it would be desirable if you would encapsulate in a particular, in a specific ground, the contentions which I've just rather inadequately summarized.
My lord, I was having a little difficulty logically following the contention. If you could
Sorry,
just
you were having difficulty
logically
following
follow,
what
I would
I'm
briefly sketch them out again. I really want to answer them.
So I didn't hear that.
I was having some trouble following what his lordship was saying.
Right.
So I'm simply asking if his lordship could briefly set it out again so I can answer
Yes.
it properly.
Part of your submissions to us consisted of saying that the judge dealt in his summing up with the case against and the evidence against Rogers and the evidence against Burgess all together, such that having dealt with the evidence against Rogers, he then went on to say, but of course, that's not evidence against Miss Burgess. And you said that that was in effect a tangle from which there wasn't an escape. And as I had understood you, what you were saying is that what the judge should have done is to compartmentalize the cases, A against Burgess, and A against Rogers, and B against Miss Burgess, so as to identify what exactly was the evidence admissible against Miss Burgess. Forget about the evidence against Rogers. So to identify what was the evidence admissible against Burgess, and having done that, to examine with the jury the possible conclusions that they could reach in relation to Miss Burgess, in reliance only on the evidence that was admissible against Burgess. And you gave an example that there were a number of possible permutations, that a meeting was arranged, but either a meeting wasn't arranged, a meeting was arranged, but it wasn't going to take place at the apartment. If it was going to take place, it doesn't follow that it was going to involve murder, etc. Now that seemed to be the basis of your submissions, which I hope I have understood,
Yes.
albeit I may not have expressed them as well as you have done. But if those are your submissions, it's not entirely apparent to us that they fit into your grounds of appeal as presently formulated.
Yes, my lord.
Is that any clearer?
Yes, my lord, I understand now.
Mr. Richardson, if it helps, it seems to me that you were always going to make this point. It's not as though you've dreamt it up on the hoof while you've been before us, but you'd put it in paragraphs 42, 43, and 44 when dealing with severance. I think what we're saying is that rather than belonging
Yes,
in the severance ground of appeal, it ought to be a freestanding ground of appeal.
and
There's a relationship between the two, but they are different points, one arising at the moment of the severance ruling, the other arising in the course of the summing up.
yes, I think I understand now. If I follow my lordship's suggestion, if I were to frame it in a ground of appeal, if I had to do so sitting here ex tempore, as it were, I would say that the ground would read that his lordship inadequately assisted the jury with the task of applying the admissible evidence against Ms. Burgess to the law that he had directed them on in such a way so that their verdict could be considered safe and satisfactory.
Yeah.
If I had to do it ex tempore, that's how I would frame it.
Well, that sounds pretty good as a way of doing it on the hoof. But could you actually put it down in writing?
If my lordships allow me to work on it whilst Ms. Mulligan's making her submissions, yes.
Yes. I wasn't requiring a literally instantaneous response.
Yes, but I now understand what his lordship requests. Yes.
Yeah, thank you. Very
Thank
good. Okay. Yes. Ms. Mulligan, I think it's your turn now.
Thank you. Good morning. Can the court hear me?
Yes.
Yes.
Okay. I have St. George's internet, and sometimes it comes and goes. So I'll try to go a little bit slowly in case you need me to repeat something. If we turn firstly to the skeleton submissions on behalf of Ms. Rogers, you'll see that some of the grounds are varied just a little bit from the notice, and that some things will not be argued.
Right.
So set out there, you'll see the first ground, the abusive process. Second ground was the no case. On the third ground, in the notice of appeal, it had indicated that there were new or late opinions of Jan Johnson that were going to be relied upon as having been improperly put before the jury. That won't be argued, just in relation to Dr. Obafunwa.
Right.
The fourth ground, offering witnesses to, or allowing expert witnesses to offer opinions outside of their areas of expertise, won't be argued. And the other grounds will be argued.
Right.
I should also indicate that paragraphs 1 and 7 are really quite connected. They both deal with whether there was a fair trial, whether there could be a fair trial, or whether it ought to have been stayed.
Yeah.
All right. Dealing firstly, setting out the case against Rogers. You've now heard a fairly lengthy submission by my learned friend, Mr. Richardson. I'm going to try very hard not to cover the same ground, but Mr. Rogers' case is of course different. The case against Mr. Rogers, as you've seen, depended almost entirely on Katrina Card and Danielle Foley. There was some forensic evidence, being that of Dr. Obafunwa and Jan Johnson, but as the court, the learned acting magistrate pointed, or Mr. Attridge pointed out to the jury that if they were not satisfied as to the reliability and credibility of the accounts given by Card and Foley, they could not convict on what remained. That the other evidence would not be sufficient for them to find beyond a reasonable doubt that Mr. Rogers had committed this murder. So really, the focus in much of my submissions will be Ms. Card and Ms. Foley and how they
Yeah.
were dealt with by the trial judge. As you can see, both civilian witnesses, and I didn't put particular references, I don't think it's an issue, that they came forward after the events. They both had an axe to grind. Ms. Foley even admitted that they had a common enemy, and that was Mr. Rogers in her evidence. They both wanted, at the time Mr. Rogers was in custody, they wanted to stay there. Katrina Card in particular hated the appellant by the time she contacted Crime Stoppers to provide information. She did not want him near her daughter, their daughter. She was bitter about his extramarital, his affairs with other women and with Danielle Foley, and the matter that he was serving time for, which involved a child, an offense against a child. At paragraph 6, I set out that Danielle Foley came forward at Ms. Card's request. They had become friends, although in their evidence, Ms. Foley seems to admit that more than Ms. Card. And in our submission told a remarkably similar story. Both Ms. Foley and Ms. Card as to the alleged confessions told years apart. What was significant, in fact, about Ms. Foley, some detail to take you to the evidence, was that she had told the police, very clearly told the police, that Mr. Rogers had said certain details to her, made certain admissions. And she recalled him saying particularly about hiding behind the couch, and that he had crouched down behind the couch, and that he had told her that. When it came to trial, she indicated in the witness stand for the first time that we're aware of that in fact, it was Ms. Card who had given her that information, told her that detail. That was and will become important in my submissions because Ms. Card continued to maintain that they never discussed the details. Katrina Card also testified about a knife. She said that it had been in their home. Very large serrated edges down both sides of the blade. This became very important in the trial. Starting at the tip of the knife, so the serration starting at the tip and ending just before the handle of the knife. And she claimed it had went missing after the murder and that he had buried it in a particular location along with other evidence. Years later, that search turned up nothing of that area. The yards were dug up and nothing was found. The key points that will be raised is that the evidence of Ms. Card and Ms. Foley are inconsistent with other evidence, sort of physical evidence in the case, expert evidence in the case, even the Crown's theory of the case, and divorced from what I would submit as reality. The forensic evidence in the case was from Dr. Obafunwa and Jan Johnson. And I'm going to take out the part that said outside of his area's expertise, but Dr. Obafunwa in particular was problematic. Jan Johnson, her evidence about the footwear examination was not created and provided until the eve of the first trial. So in July 2019, there had been no opinion up till then about the footwear comparison, but certainly by January of 2020, we had had sufficient time with that evidence. It had been an issue at the first trial that we did not have sufficient time, but by the second trial we did. Dr. Obafunwa is a different issue. Ultimately, despite his, I would say his strident nature on the stand, Dr. Obafunwa could only say that the knife or knives, because he couldn't say whether it was one or two for sure, caused the injuries, may or may not have been a single serrated edge with a flat edge, straight edge on the other side, or a knife similar to what Ms. Card described with serrated edges on both sides. Similarly, Jan Johnson's opinion that some footwear that was allegedly seized from the appellant's home may or may not have caused the footwear impressions at the scene really didn't take the jury any further than Card and Foley, because the most she could say at the end of the day was, well, it could have been, might have been, it could have been anybody really. And her evidence that the impression at the scene was maybe between size, I think she said 7 and 11. What will become important in my submissions is that there were a second set of footprints, blood at the scene. Jan Johnson's opinion, as called by the prosecution, was that those had to have been left at roughly the time when the injuries were inflicted. The second set of footprints were smaller and really completely unaddressed by the prosecution or the learned trial judge in his summation. The Crown's theory and the Crown's position to the jury was that Cleveland Rogers had committed this murder alone. There was never any suggestion that he had committed it with anyone else. Yet the prosecution's expert, Ms. Johnson, said there were 2 sets of footprints aside from the victims that would have been left at the time of the bloodshed. The evidence of the payment of money, I apologize because I've left that sort of as an after fact in my written submissions, because it is the kind of evidence that is almost impossible to refute and very easy to make up. You know, at some undisclosed date, at some undisclosed time, someone came in the yard and gave Mr. Rogers $500. Mr. Rogers, according to Ms. Card, said it was Ms. Burgess. Ms. Card says, well, at some point I had to call Ms. Burgess to see if she had the messages, which she presumed meant money, for Mr. Rogers. On some other undisclosed date, Mr. Rogers is alleged to have said, well, she was going to pay me $5,000. It's the kind of evidence for which there can be no corroboration. There's no support for it. And the support that my learned friend, Crown Counsel, points out in their submissions I will come to is not support at all. So the case against Mr. Rogers, as I say, was largely these 2 women and the, what I would say, almost meaningless expert evidence as it relates to Mr. Rogers. So grounds 1 and 7 deal with abusive process. And it combines all of these types of issues into one because it led in our submission to a very unsatisfactory trial. The matters complained up specifically in relation.
Just before you get to paragraph 15, you say at 14, the second sentence, as such, the learned trial judge ought to have stayed the proceedings. Which trial judge is that one?
Well, and that's a very good question. The application originally for Mrs. Justice Simmons, and I made some inquiries trying to if and when a ruling was made, but my recollection is that it was also brought before Mr. Justice Attridge, and the Crown seems to accept in their submissions at paragraph 37 that there was such an application, but I've yet to find a ruling. I know it was dismissed, but I've yet to find a written ruling or reasons in the record. It is quite likely that it was raised on several occasions because there was a number of pieces of disclosure that were discovered during the course of the trial to have gone missing, or evidence that's gone missing, disclosure that wasn't made, was made late in the day. There was a exhibit list that we finally received near the end of the trial. On it, there was reference to a bunch of love letters and notes between Miss Burgess and Mr. Gibbings that changed sort of the nature of the evidence that had been put before the court. It was just constantly coming up that there were things that were missing. We didn't know that all the photographs, the footprints that had been taken from the shoes that had been worn by first attenders, we didn't know any of that was missing until we got into the trial and asked for it. And then there was this hunt for these items, and they didn't come up with anything. The same with the.
Just a second. This is very confusing.
Okay.
If you quite rightly say that the matters upon which you rely in paragraphs 15 and following relate very substantially to matters that arose after Justice Simmons had reached her ruling, and relate to what was or wasn't available, as it turned out, at the second trial. But it seems to me inconceivable that if there was an application to stay the second trial on these quite substantial, in terms of length, grounds, that the judge wouldn't have given a ruling of any kind.
And I wish
especially this judge.
Yeah, I wish I could give you a better answer. I recall Mr. Mahoney relying on, in large measure, the case of PR, as he does before this court. I recall making arguments, but I cannot tell you whether that happened once, twice, or three times, or when it happened during the course of the trial. And I don't see reference to it in any of the rulings that have been provided. So it's difficult. I don't know what to say in answer to that. I can't tell the court whether there was more than application dismissed, whether there were reasons given on any occasion when it may have been raised.
But that, if I may say so, Ms. Mulligan, is a very unsatisfactory way to leave it so far as we're concerned.
Yes, I agree. But I don't have an answer for you at this time.
You don't have the detail. All right.
You will see in the in relation to the footwear evidence.
I just wonder whether I could just break there and ask Mr. Mahoney. Can you help us on this? You say in paragraph, the Crown says in paragraph 37 of its submissions, that the trial judge was correct in dismissing Rogers' application to stay proceedings as an abuse. In paragraph 37 of your submissions, which trial judge are you referring to?
I'm referring to, my lord, Mr. Acting Justice Attridge, because the Crown's submission in reply to that application for stay of proceedings and exclusion of evidence, was filed on the 10th of January, 2020. And the application was actually heard by Acting Justice Attridge, and he did make a determination.
And when did he do that?
Excuse me, sir?
When did he do that?
Give me a second, sir. Checking.
Well, let's not take time on it if it takes time to find out.
Sure.
But as I understand, it, well, firstly, you say the Crown's response was on the 10th of January, 2020. Does that mean that there was a written response?
I can't recall offhand, sir, but the judge did actually give a ruling in court.
Well, we need to find it, Mr. Mahoney.
Oh, it's on the 15th of January, 2020. It was
Yes.
in Family Court number 2 at 9:30 a.m. Mr. Daniels was present and the application was denied. I think the hearing was actually on the 14th of January, I think.
Well, it sounds from that as if the judge at any rate had your submissions. If the hearing was on the 14th and there was a Crown response on the 10th of January, that response must presumably have been in writing.
The Crown's response, yes, sir.
Yeah, so presumably you've got that somewhere.
I do, sir.
And if it was a response, it must have been a response to something which would itself would have been in writing.
Yes, sir. I have in my record an application for stay of proceedings, exclusion of evidence signed by Ms. Mulligan, and that was dated 2nd of July, 2019.
So that was before Justice Simmons.
Yes, sir, it was filed, but I don't think the application was actually heard. Because in that, when we did the first trial, we only went through one witness, which was a police photographer. And after 5 weeks, we were unable to proceed any further.
Right.
All right. So that was what I wasn't remembering correctly. So Judge Simmons did not hear it then, and Mr. Justice Attridge did.
Wait a moment. We've been given to understand that Justice Simmons gave a ruling on the 1st of July.
No, sir. The application by Ms. Mulligan, her document was signed on the 1st of July. I'm not sure when it was filed, but the document I have is dated the 2nd of July, 2019.
The ruling by Mrs. Justice Simmons on the 1st of July is in relation to severance.
Yes.
That was
I see.
severance, but not the application for stay of proceedings by Rogers and exclusion of evidence.
Oh, I see. Yes, I'm sorry, I'm getting confused with the applications.
There was an amended application filed by Rogers dated July 9th. Same application, but some amendments made to it to deal with Ms. Johnson's evidence. And I provided that to Mr. Coelho. But I didn't have, obviously, a good recollection of what had happened with the application.
I'm still puzzled, Mr. Mahoney, as to why, if a ruling was given on the 15th of January, that it didn't find its way into the bundle of arraignments, rulings, and summations, which deals with the arraignment on the 15th of January.
My lord, I would have to check further in regards to that.
Right.
Knowing the acting justice Attridge's habit, I suspect he would have given a written decision, if not on the same day subsequently.
Right. Well, this is all singularly unhelpful. We have taken steps to secure the severance ruling of Justice Simmons. We now need to have the stay ruling, which it is apparent was given and which nobody has caused to be put into the record, of the 15th of January, 2020. seems to me quite absurd that we're dealing with appeals from orders, none of which have the rulings being provided to us.
My lord, may I just make a correction? The application for the stay actually started on the 14th of January and continued over onto the 15th.
Yes,
And the
okay.
ruling was given on the 15th.
Yes, sir, but it actually started the day before, the 14th.
Well, yes, that's all true but uninteresting. What we actually need to know is what the ruling said. Okay, well, we'll have to pursue. Have you got have you got a copy of the ruling?
I will check our record, sir.
We really do need it because certainly the English authorities make clear that appellate courts only interfere with judges' decisions on abuse of process if the judge has clearly gone wrong. And we do rather need to see where he is said to have gone wrong. Not just in the abstract, but by reference to what he said. It's not a rehearing, it's a review of the judge's exercise of discretion. At least that's how it would be seen in England.
Mm. What are you looking for, Mr. Mahoney?
Sir, I'm checking our record if we may have copies of it in the pro law, sir.
Right.
And I am looking to see if Mr. Daniel sent me a copy, since it appears he attended. I don't recall having seen a written copy, so I mean,
Well, there may not be one. The judge may well have given an oral ruling, which nobody has taken the care to produce. Well, I don't think we should spend time doing nothing. And we should consider, Ms. Malik, your submissions on this De Bene essay, with the qualification that, considering your submissions as to why a ruling was wrong when we haven't got a copy of the ruling, is a slightly curious exercise.
I can begin with the second ground, the no case ground, if that assists.
Well, that might be sensible if there was a reasonable prospect of getting the ruling today or tomorrow. But the trouble is, I suspect that it was given orally and nobody has transcribed it. Why don't you go to no case to answer now, and we'll see where we get to in relation to the ruling we haven't got a copy of.
Okay.
Right.
All right. So with respect to no case to answer, clearly there were two witnesses who gave confession evidence. So it was an unusual application, I suppose, in that respect for Mr. Rogers to make. But we submit their evidence was so inherently weak, and the risk of collusion, the actual collusion, was so clear that it ought not to have been left with the jury, that it was unsafe. There are inconsistencies with other evidence as well.
Right.
So we asked the judge to exercise his discretion to remove the case from the jury because they could not reasonably rely on these two witnesses. And if they could not rely on these two witnesses, there was no other evidence capable of supporting a conviction. I've set out paragraph 28 that it was inherently weak for the following reasons. And some of these are common sense reasons, some of them are reasons to do with the evidence, but neither witness, having received the alleged confession of murder, went to the police immediately. They waited some many years. And Daniel Foley's statement to the police came some 4 or 5 days after Miss Card's. So it wasn't independent. They went to the police and just arrived there separately. Clearly, Miss Card had spoken to Miss Foley, and Miss Foley ended up at the police station. One of the mysterious things is that both witnesses continued their relations or the relationships with the appellant Rogers despite his confession to murder. Common sense would suggest that they might have had some concerns about going on to not only become pregnant with the appellant Rogers' child, getting back together with him. Miss Foley actually was going to be married to him after the alleged confession. So there are some common sense issues there that if someone confessed murder and you're so motivated by the wrongness of it that you come forward to the police years later, it would seem odd indeed that you would continue and want to plan a life with the appellant and have children with him. Miss Foley's explanation was extremely strange. Her explanation for not doing anything about it sooner and not going to the police and just continuing on in her relationship and planning her wedding was that she didn't know how to take it. She didn't know how to take it, the confession to murder. One would have thought if she didn't know how to take it, she would have asked some questions. What do you mean, Cleveland? What do you mean? What are you saying? Did you really do this? But no, none of that allegedly happened. She just didn't know how to take it, so she carried on. The witnesses, we say, clearly colluded and had a common enemy, a common interest in keeping him in custody. So they had a motive for lying. The animosity was clear in the evidence. And I've set out the sections of their evidence where it's clear, but it was very clear. I mean, Miss Foley wrote letters to Mr. Rogers in custody that were just threatening and full of hate. It was very clear that they had this feeling of animosity, both of them, and maybe for good reason. I'm not suggesting there wasn't reason, but it was a long time before they came forward. And when they did, they had built up that feeling. Getting to the actual evidence, the inconsistencies, Katrina Card, this is at paragraph 30 of my submissions, Katrina Card, and this is important, she testified that the appellant came home on the day of the murder, so he was home at around 6 p.m. So on October 25th, 2016, he was home at 6 p.m. and then he left. And she says he returned around 9 p.m. for about 10 minutes. And she didn't see him again until 5:30 the following morning. Importantly, she testified there's nothing unusual when she sees him at 9 p.m. Bear in mind what you heard yesterday from Mr. Richardson, that the voicemail by Katrina Card that was left for Mr. Gibbings saying, you didn't show up, I'm leaving work, I'm going to Lobster Pot, and then to my dad's. That was left at 9:07 p.m. So by that time, the Crown theory is that it was answered because Mr. Gibbings was already dead. Mr. Rogers is home at 9 p.m. with Miss Card, according to her, and there's nothing unusual about him. He's wearing the same clothes he went out in, not covered in blood, not sweating, doesn't have any marks on him, nothing like that. There's nothing unusual about him. Importantly, she has a very clear memory of what he was wearing. She recalled, and I set it out at paragraph 31, that he was wearing a black long sleeve top, black track pants with 2 red stripes going down the sides of the legs, and black and red Nike sneakers. And that he was still wearing the same clothes and footwear when he came home at 9 p.m. Presumably, that would be after the time of the murder. Because by 9:07, there's no answer on Mr. Gibbings' phone. We have all the evidence from the Pierres about what time he left there. It was very clear on the Crown's case that the suggestion was he had left shortly after 8. He would have been at the apartment shortly thereafter, 8:15, 8:20, and was killed.
All the timings to which she refers are approximations, aren't they? Whether she said so or not, with a witness testifying to these kind of events, even within a normal time, let alone after a long period of time, nobody ties them to minutes, do they?
Well, she didn't express any equivocation or uncertainty about it.
Well, you're skeptical using expressions like around 6 o'clock and that sort of
Yeah,
thing.
the 6 o'clock.
Around 9 p.m. She said he returned around 9 p.m. I mean, I haven't got the transcript in front of me, but
I can take you.
surely anybody, even if they don't use the word around, if somebody says he came back at 9 o'clock, anybody's going to make allowances for the exactitude of that, aren't they? Whoever the witness is.
I suppose, but let's just take you to, if I can just take you to her evidence.
So page 11 at line 22, he came home about 9 o'clock.
Yeah.
Yes. So she goes on, he came home about 9 o'clock, 9 p.m., yes. And this is in Mr. Mahoney's examination of her. And then he didn't come home till 5:30 in the morning. He left. How long after that 9 p.m. return? 10 minutes, if that. So it's not just a matter of minutes. She's clearly, at one area she's been consistent on throughout is that it was about 9 p.m. when he came home and he left about 10 minutes later. If the Crown theory, and we'll come to this because there's some confusion, but if the Crown theory is that the setup was at 7:15 by Miss Burgess luring Mr. Gibbings to the apartment. And then she contacted somehow, because there's no evidence she did, and I'll come to that, Mr. Rogers, and got him over there before Mr. Gibbings arrived.
Sorry, do you mean 7:15 or 7:51?
Well, my concern is that I think yesterday it said it was 7:15, but in the record of the phone calls that are set out by the police analyst, it says 7:50.
So we ought to work on the basis that it is 7:51, should we not? That 7:15 is as Mr. Richardson said yesterday, it's just an inversion of the numerals and it's unhelpful and confusing.
Yes, so let's work on 7:51. That's at the Record on Appeal, volume 2, at page 335, it looks like.
Yep, that's 7:51:49 seconds.
So, and the Pierres have him leaving not long after that. So he would have arrived. We heard some evidence about time and distance, but let's say he arrived as late as 8:20 at the apartment. It's not.
Where's the evidence of that?
We heard some evidence from various witnesses about the length of time it would take to travel, and I'm just trying to recall.
But we don't know when he started.
No, we know from the Pierres roughly when he started. And And we also know that by 9:07, he didn't answer his phone.
Yep.
And the
I mean,
Crown-
people don't answer their phone for different reasons. I don't think we can take that as an indication that he was dead by then. Don't we need some better evidence?
Well, that was certainly the Crown's position, that she had made that call knowing that he was dead and wouldn't be answering. She left the message after the murder. That was the Crown's position. Yeah, I suppose some better evidence would have been helpful, but that was their theory. I'm just going to look up the evidence of the Pierres. May for a moment. Not seeing it in Mr. Pierre's, it must be in hers. Because she had remembered that she had a class or something she had to get to, and that's how she was. One more moment. And I'm not seeing it there.
If we look at the evidence of Mr. Pierre on page 29, at line 15, this is where Mr. Pierre says he walked out of the front door of the home. That was the last time, and this is the question, last time you saw and spoke to him, which was about 8 p.m., and he says yes.
Yes. I knew I remembered it from somewhere. So he is leaving from their home and heading to Derwent Lane by around 8 p.m.
And we've got a map which shows how you get from one to the other.
I think Mr. Patterson may have spoken to it too. I'm just gonna look at my friend's submissions. But,
Just ask the president. Yeah, Sir Christopher, could you give me that, the
Yes,
reference?
it's
the
page
map?
69 of volume 1 of the Record of Appeal.
Right.
And it shows various routes. He's supposed to have gone off in a white van, if I remember right.
Yes, correct.
And it shows various routes from Crossland Lane to Crossland Lane to Derwent Lane. But it doesn't seem that it would take you very long.
It's not far at all, is it?
No. The yellow route is said to be a total distance of 560 meters.
yeah, that's from Cleveland Rogers' home to Derwent Lane.
Oh, I see. Yes, you're quite right.
And if Cleveland Rogers left his home at 6 and didn't arrive home till 9 p.m., it's kind of irrelevant because it would suggest he didn't start out from his home if in fact he attended Derwent Lane. But the Pierres, let's go to that. Pierre's were living at Devil's Hole, Somersall Road, 23 Ramgoat Hill at the time. So he would have to travel from Devil's Hole to Derwent Lane.
Yeah.
Which
Right.
certainly was not a lengthy trip. It wasn't around the corner, but it wasn't a lengthy trip. My suggestion is that if the best evidence we have is that he left around 8 p.m., then he most certainly would have arrived at Derwent Lane no later than 8:30, but probably earlier. And the Crown theory is that whoever was there to kill him was laying in wait for him. The Crown position to the jury was that had all been set up, that whoever was going to kill him was there laying in wait, and they say it was Mr. Rogers. And clearly that was based in part on the evidence of Miss Card and Miss Foley, who claimed that Mr. Rogers said he was waiting behind the couch. So if Ms. Card is at all right about her times of when she says she saw Mr. Rogers, it makes no sense. First of all, the Crown position, the evidence of Jan Johnson about the footwear was all about Mr. Rogers having potentially been a person who could have left the work boot impressions at the time of the killing. But Miss Card, her evidence is that when she saw him at 6 p.m. and again around 9 p.m., he was wearing sneakers, Nike sneakers. There's no evidence that at either time he left with a change of clothing or overnight bag or anything like that. And then when she saw him around 9 p.m., there's nothing wrong with him. There's nothing unusual about him. I think it's a reasonable inference, and the only inference to be drawn, that if Mr. Rogers had been wearing that outfit and had killed Mr. Gibbings in the manner that we see depicted in the photos, we see the blood everywhere, there would have at the very least been some blood on him. But none of that. There was nothing unusual about him. He didn't smell. He didn't seem unusual. He seemed normal. So that's the first sort of issue, the timing issue with Miss Card's evidence, and the clothing issue is inconsistent with the Crown's theory and inconsistent with the likely time of death of Mr. Gibbings. The other problem that arises on the evidence is that, of course, Miss Card says that this was being done at the behest of Miss Burgess, and that's evidence against Mr. Rogers. And the Crown certainly adopted that position, that Miss Burgess lured Mr. Gibbings to the apartment. So at 7:51, she makes the call and finds out, yes, let's say that's so. 7:51, she makes the call and finds out, yes, he will attend. He will meet with her. Presumably, she had to communicate that somehow to her hired murderer between 7:51 and at the very latest, probably 8:30. If you look at the phone records, we have phone records for all of her phones. And the calls made are all accounted for. Lori and Kevin Hudson, sorry, this is on page 335 again, volume 2 of the record on appeal.
So we know, there's no evidence that Ms. Burgess called Mr. Rogers as soon as she'd finished talking to Marcus.
There's no evidence she ever called him on any occasion for any reason, or that he called her, other than Miss Card. But there's nothing in the record here. Lori Hudson was a good friend of hers, and she was spoken to by the police. Vernell Keynes, you would have seen in the evidence, was a good friend of hers. The lobster pot, she does in fact call at, looks like 8:09 p.m., as she said, she had put in the voice message. And then more calls with other friends, Lori and Kevin Hudson, none of whom had anything to do with Mr. Rogers. So the Crown did not present any evidence of any communication by any means between Miss Burgess and Mr. Rogers that would have moved Mr. Rogers from wherever he was, because on the evidence of card, he wasn't at home at Crossland, to over to Derwent Lane.
But the phone call at 7:51
Yes.
was a confirmatory phone call or a varying phone call, however you want to look at it, wasn't it? Because there was a witness who said at 7:15, Marcus was already referring to an arrangement to meet Katrina at the house. A witness called Lauder.
Just have a look.
It's referred to in Mr. Mahoney's skeleton at page 4.
Would have been read-ins.
All I'm suggesting is that if there wasn't much change in the arrangement with the deceased, she wouldn't need to communicate anything to Rogers after the 7:51 phone call.
And I guess I don't know how to answer that because we don't have the evidence of Mr. Lauder. Although it may have been a read-in statement, I can't recall.
He was a read-in. He was a read-in.
Read-in, okay.
Read because it was agreed or because he wasn't available? Or...
I think
It wasn't agreed. It wasn't agreed.
I think he might have been, was he deceased, Mr. Lauder?
It was agreed, sir. Well, we're about to make the application and we're advised that there wouldn't be any issue, but the judge still advised the jury that the defense would have liked to have cross-examined him.
That's correct. That's correct.
So for what it's worth, it was never tested, his recollection of the time, because he was deceased and the statement was simply read in. So I'm not sure I can say much more about that, whether that should be accepted as being the correct time or even the correct position. But what we do know is that that night, Mr. Givings was at the Pierre residence, did not seem to be talking about going to meet up with Miss Burgess until the phone call. He was working on a computer and his friend was playing his Xbox and he was having a chat with Mrs. Pierre in general about the relationship, but the first going anywhere in relation to Miss Burgess seems to come after the phone call. So I can't assist more than that with respect to Mr. Lauder. But in any event,
was there anything put before the jury to suggest that Mr. Lauder might not be a reliable witness? I mean, sometimes when deceased witnesses are read, it's subject to the proviso that he had a record of dishonesty, or he was not very bright, or that he was badly disposed towards somebody or other. Was there anything of that sort?
I don't recall anything of that sort.
No.
being led.
Nothing on the face of it why a jury shouldn't have accepted his evidence.
Well, unless he was wrong about the time, as an ordinary person would be years later.
Approximator as well.
Yes. And I go back and look at his statement to see how he came to that knowledge. I don't have it in front of me. But in any event, you would think then there would have to be some communication at some point with Mr. Rogers. And there is no evidence of that at all, whether it be before 7:15, at 7:15, at 7:51, after 7:51. There is no evidence of any communication and no evidence given by Ms. Card that there was any phone call or nothing like that. So what we have then on the timing issue is the best evidence before the court is that at both 6 and about 9 p.m., Mr. Rogers is wearing this clothing and footwear that is inconsistent with the Crown theory, the footwear. On him appearing normal at around 9 o'clock is inconsistent with the Crown theory that he just committed a brutal murder. The fact that there was a third set of footprints is inconsistent with everybody's evidence, Ms. Card's, Ms. Foley's, and the prosecution theory. And then Ms. Card's evidence goes to the fact that she says, and this is found at paragraph 33 of my submissions, that he then arrives home at 5:30 a.m. So he leaves again at 9 p.m. wearing the same smart tracksuit and Nike sneakers and arrives home at 5:30 a.m. And at that point, she says, oh, I don't know what he was wearing, but it wasn't the same. And she says that he was odd then. He told her to turn off the lights, lay down in the bed. He was still, he was looking up at the ceiling. When she asked what was wrong, he said nothing. Interesting, this looking up at the ceiling comes up again. Danielle Foley, years later, she doesn't know when, perhaps in 2014. She says, of course, the appellant also confessed to her. And she claimed when the appellant did so, he was laying in bed and he was looking up at the ceiling and just happened to come out and tell her that he had murdered Marcus Gibbings because he was stalking his sister. Miss Card's version of the confession was that he had murdered the guy, or Trina's boyfriend, is the name, because he was cheating on his sister. But they both had an element of laying on the bed and looking up at the ceiling. Oddly coincidental element, I should say. So that's some concern. But then we go to Miss Card's evidence about when she first heard about the murder, which gave rise to her making inquiries and gave rise to this alleged confession she received. So she says on the night of the 25th into the morning of the 26th is when Mr. Rogers came home ultimately at 5:30 in the morning and acted strange. We know that Mr. Gibbings was not discovered until after 12 p.m. on Thursday, the 26th, when his co-workers went to look for him. At trial, Katrina Card's evidence initially was that she heard on the radio Friday morning, so a day later after Mr. Gibbings was discovered, that there had been a murder. And she was fond in her evidence of saying, I remember it like it was yesterday. And she even said that to the police. And she even recalled she was changing a baby at the nursery where she worked at the time that the news of the murder came on the radio. And she said she had a gut feeling, so she called Mr. Rogers to ask if he had something to do with it. And he told her not to talk on the phone. And when she got home, she found him near the stove and asked him to tell her he had nothing to do with the murder. And she testified that he said, "Yes, I fucking done it." Interestingly, in cross-examination, her statement to the police was read, and she had told the police she'd gone to day, so the Thursday, and she remembered it like it was yesterday. She was changing the child, and the news came on the TV. Well, there would have been no news either on the TV or the radio the following morning because he had not been discovered until noon. But by the time she testified at trial, of course, her evidence had changed from Thursday to Friday. And if we look at that evidence, I think it's quite telling. If we go to Katrina Card's evidence.
Page.
At page 97. Clean it up myself. At page 97, she's being cross-examined by Mr. Daniels. And at line 12, roughly, she's asked about this question. It actually begins line 9. When my learned friend, Mr. Mahoney, asked you earlier today specifically about, he was asking about the Homestead Nursery up Khyber Pass and whether you went to work on Thursday morning, and you said you did. And whether you went to work on Friday morning, you said, yes, you did. And you said that while at work is when you heard this radio announcement and you remember it like it was yesterday, yeah? Yes. And then you tried to qualify to say it was like Friday early morning, yeah. It was the following day. Pardon me? It was the following day. It would make sense. I don't know what time the deceased body was identified, right? No. In terms of news generally, it did come on the news though. Did you read the papers? Did you read the papers sometimes? So she then finally reversed to just saying, well, it came on the news. If you go to, I guess I should have started earlier, page 94. I apologize, I should have started earlier. Because you can see she's clearly talking about that same morning at line 12, but you don't feel so disturbed to call in sick and stay home with Clevey based on the way he acted. She called him Clevey, according to your version of events. No, I had to go to work. And when you got to work, you told the police, I'm going to say you said, I remember it like it was yesterday too. I was changing a child. There was a little TV there. It came on the news. Something wrong, right? And the police came on the news. You said the murder. The police went on to say, for clarity, when did this, sorry, you may not be hearing me. For clarity, when did this occur? And you say this was in October 2006. You didn't say, but this was on Wednesday night, October 25th, 2006. You didn't give that type of specificity. So he goes on to ask, the police are asking when you saw it. Because you told the police at the bottom of 95, because you told the police that it was a news report at like 10 a.m., right? Right? But there hasn't been any TV news. It was the next day. But let's start with this. The TV does not give a news report at 10 a.m. Well, it came up on the TV, But today your evidence is that it came on the radio, right?
I'm sorry, you broke
So
up. I'm sorry, you broke up.
I'm sorry. I was just reading the passage there in the transcript that where she comes down to it, she's given inconsistent versions about whether it's the next morning when she goes to work or the following morning. She's given inconsistent versions about whether it was the radio or the TV. It's pointed out to her that there would have been no TV news at 10 a.m. And she says, well, it came on the news. And that's the difficulty with her evidence, Miss Foley's evidence. It is so vague and so difficult to pin down and contradictory.
Ms. Mulligan, I understand the point about the confusion between TV and radio, but look at 97 at the bottom, where the question put by Mr. Daniels is, and then you tried to qualify to say it was like Friday, early morning. Yeah, answer, it was the following day. And she repeats that. Now, which day is she referring to there?
She seems to go back to saying it's the Thursday.
Why do you say that?
Well, because she says, I can just get to it. Let me just find another reference to it.
I was kind of, you can't say what the following day, as she said it twice on page 97, refers to.
I guess, no, I can't say with certainty what she says there refers to. It struck me when reading the whole passage that she had gone back to saying the following day, following Clevey coming home, because when you look at what she's asked there in the middle of 97, she's asked about it being the Friday morning, and she says it was the following day. It was the following day. It seemed like she was correcting Mr. Daniels, but I can't be certain. You're right. That's my interpretation.
But Mr. Rogers, when he came back at 5:30 in the morning, that would be 5:30 in the morning on the Thursday.
Yes, but
And so the following day would be the Friday.
I suppose, but what she seemed to be answering in some was that she didn't stay at home with him. That was at 94 because she had to go to work. And she told the police it was that morning that she had to go to work, that she heard it on the news. And then in her evidence, initially she said Friday morning, and what the following day, I can't say for sure what she meant.
Right.
So that's where we're at with that.
Sorry, I'm getting hopelessly confused by this. If you go to page 94, she's asked at 12, but you don't feel so disturbed to call in sick and stay home with Clevey based on the way he acted. Answer, no, I had to go to work. And then the question, when you got to work, you told the police, and she says, I remember it like it was yesterday too. I was changing a child. There was a little TV there and it came on the news. So at that stage, she seems to be saying, this is all on the Thursday. I didn't feel so disturbed to call in sick and stay home with Rogers. But I went off to the nursery and I heard it when I was changing a child at the nursery. Pompty, 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 pom. And then if you go to 95, at 19, she's asked, and the reality of the situation is that the police had to query with you about seeing the news on the TV. Answer, right, because you told the police it was a news report like 10 a.m. Question, but there hadn't been any TV news. Answer, it was the next day. Now that would appear to be an indication that it wasn't the Thursday, but it was the Friday.
Yes.
And that is picked up at 97, line 20. And then you tried to qualify to say it was like Friday, early morning. Yeah, Answer, it was the following day. It was the following day. Right, I mean, it would make sense, as it would. And you don't know what time the deceased body was identified. Well,
Yes,
it
I agree.
looks as if she said originally it was the Thursday and then said it was the Friday.
And she had said
Unless-
to the police it was the Thursday, but when she gave her evidence in chief, she said Friday. So that makes sense to me as well, that she's trying to say it was actually on the Friday.
Oh, in her evidence in chief, she'd said Friday.
Yes,
Right.
yes.
So she started off at Friday and ended up with Friday.
We started off with Thursday with the police, which is what she was cross-examined on, that she said it was that morning.
Oh, I see.
Then when she testified in chief, she said Friday. She was cross-examined, and it looks like you're right. She's gone back to Friday. She's resiled. She's changed it from the TV to the radio, and then says, I don't know, it was on the news.
Yeah, she told the police it was Thursday, but in her evidence in chief, she said it was Friday.
Yes.
And that's where, in cross-examination, she said it was effectively.
The evidence of Miss Card as well was that the motive for the murder was that Mr. Gibbings was cheating on Katrina Burgess. I mean, it can't really go without notice that according to both Miss Card and Miss Foley, Mr. Rogers was to use Mr. Richardson's words, an Olympian cheater. He was cheating on them constantly. It would seem a strange reason for him to be upset. As well, we know from the evidence.
The thing that was upset, it would have been Miss Burgess who was upset.
But we know from the evidence they had already split up. They were out. And we learned later on in the trial, we received disclosure of some letters and emails which suggested that Miss Burgess wanted Mr. Gibbings out of the apartment. She was ready to move on. We didn't get those until sort of the last hour of the trial almost. But in any event, it is inconsistent with Miss Foley's evidence. You know, sometimes when you try to put together a story, someone gets a word wrong. And of all the details that Mr. Rogers is supposed to have told both of them years apart, what was the reason for the murder? And according to Miss Card, he clearly said Mr. Gibbings was cheating on Miss Burgess. And according to Miss Foley, he said Mr. Gibbings was stalking Miss Burgess, which are two very different things.
But Miss Mulligan, you're
They
doing
both had a version of the motive.
you're doing what counsel always do and understandably do in circumstances such as this, where the two witnesses say something the same. He was looking up at the ceiling. You say that's collusion. And when they say something different, stalking, cheating, you say that's inconsistency. And of course, you're perfectly entitled to say that. But all these things are for juries to assess, aren't they?
Well, it would be if there was not such inherent unreliability. And why I put one case in the bundle, not because it's the same type of case. I know the Court of Appeal, the court will tell me that, but because it talks about what we look for in a reliability of a confession, what a jury should be properly asked to consider or not consider if the case is taken from them. And in this case, there is such inconsistency. First of all, there is evidence of collusion. There is evidence, proof positive of collusion.
What do you mean by collusion in those terms? I mean, there's evidence that they spoke together. There's not evidence that they adjusted their stories.
Well, I submit there is from Miss Foley.
Well,
because Miss
Can
Foley.
you just identify how,
Miss Foley, in her interview, her video recorded interview with the police, said that she recalled, and I'll take you to the passage in the evidence. Okay. So if I take you to her cross-examination,
yes,
at page 38. It suggested there that she's making up false testimony. But then at line 20, just going back to the point about hiding behind the couch and getting the detail from Katrina, correct? On page 134 of the record for my learned friends, DC 2026, and just to be fair, that would be Chris Sabin, correct? The white officer, right? He asked, okay, did he go into any specifics about how he might have done this or where? And you replied, not, I remember him saying behind a couch. He was behind a couch. You're telling the police that Cleveland Rogers told you he was hiding behind the couch. And it was a misunderstanding. When I confirmed with the police in my should have been my another statement, to state that Katrina Card was the one who told me, not Cleveland Rogers. The next question. Okay, I just want to show you your second statement that we discussed earlier. It was the 9th of August, 2018. I know what the second one is about, right? But it should have been in question. Oh, so the police made a mistake. Answer, another one should have been, they didn't put this additional detail of your corrections in the statement. And he goes through with her the second statement, which had nothing to do with this. And if you go down to page 41, line 16. Okay, but just to be clear, on page 134 of the record, the police doubled down in their interview by asking you, did he say what he was doing behind there? And you responded, just like crouched down behind the couch. So she clearly, in her interview with the police, said she remembered him saying he was behind the couch, referring to Mr. Rogers. And when asked what he said he was doing down there, she remembered him saying he was just crouched down there. When she came to trial, she testified that in fact, Cleveland Rogers never said those things to her. That Katrina Card told her those details of Cleveland Rogers' confession to her. She never gave a satisfactory explanation for why she told the police in her interview that he had told her that directly. Ms. Card, on the other hand, denied ever having given such details in her evidence to Ms. Foley.
but doesn't that suggest that there wasn't collusion rather than that there was?
No, I submit the reverse. Ms. Card, perhaps not being aware by the time of trial that Ms. Foley wasn't going to go through with saying that Cleveland had said this to her, maintained her position that she never told Ms. Foley anything about the details. Ms. Foley, on the other hand, for whatever reason, when she hit the stand, wasn't prepared to say that Mr. Rogers told her, because in fact, it was Ms. Card that told her. So Ms. Card maintained the lie about never having told Ms. Foley it, or Ms. Foley lied when she said Ms. Card told her that, but that seems unlikely in the circumstances. To make matters worse on this point, the Crown was given some time, prosecution, to make some inquiries, because Ms. Foley indicated that she had tried to correct that with the police at some point. Clearly, in her second statement, she had not, but she maintained that she had tried to correct it. And she maintained that she tried to correct it with Inspector Redfern. No information was ever provided to us by the prosecution in form of a statement or anything else as to whether or not that occurred. Detective Redfern then took the stand and was not asked by the prosecution about it, and could not be asked by the defense because we didn't know the answer because it had not been provided to us. One would assume that if Ms. Foley had corrected such an important thing about the one detail she was given in a confession by Mr. Rogers, that it came from Ms. Card, that we've had some statement to that effect, but we didn't. Or
So
disclosure.
why could the defense not ask Mr. Redfern?
The man-
Inspector Redfern?
Well, we didn't know what his answer would be. I mean, that is the kind of thing, the main witness in the trial, that the prosecution would have a duty to disclose if it had in fact happened. If in fact Ms. Foley had said, look, I got this information from Katrina Card, and I want to make a correcting statement. I didn't mean to say that I remembered Cleveland Rogers saying it, and I remembered him saying he was crouched down behind the couch. I want to correct that and advise that I got that from Ms. Card. That would have been a significant thing. And it should have been disclosed, even when the prosecution had an opportunity to make
Well,
it.
it's not that you couldn't have asked, but you thought it was wise not to, presumably because if you had asked, was there in fact a confirmatory statement, there was a risk that he would say, yes, there was.
Yeah, we didn't know what he would say. Yes, there was a
I
risk.
know.
Say,
So
yes,
the answer was either going to be yes, no, or I can't remember.
yes.
Yeah.
But we were entitled to know that in advance of his evidence.
Yeah, I follow that.
And we didn't. And it was for the prosecution really to satisfy the jury that she was being credible and that there had not been an attempt at collusion that just failed at the trial stage. And when we look at the manner in which that was dealt with by the trial judge, it was most unsatisfactory. I'll bring that up now just to give you the sense of that. At page 412 of the summation by the court, in dealing with what we said was pretty clear evidence of collusion, the court says,
I'm so sorry. Could you give me the page number again? I was looking at something else.
page 412.
Thank you.
412.
Yep.
At line 10. Ms. Foley agreed that she told the police in her statement that Mr. Rogers told her that he had crouched down behind the couch, which she accepted was incorrect because in fact, Katrina Card had told her that and not Mr. Rogers. Again, you'll consider that with perhaps the fact that Ms. Card said she did not tell Ms. Foley any of the details of what she says Mr. Rogers told her. I don't think I need to remind you, though, of how you approach inconsistencies or discrepancies that you may find exist within the evidence you've heard in this case. Ms. Foley denied, however, that all the information she gave to the police came from Ms. Card. She later added that that should have been corrected by the police in her second statement, but it was not. And she agreed that notwithstanding that the correction is not contained in her second statement, which was read over to her, and which she still signed as being true and correct, Ms. Foley then told you that there should have been a third statement because she did correct herself in respect of that and said that she shared that correction with Mr. Redfern. Of course, when Detective Constable Redfern came to give evidence later at the trial, nobody, neither the defense nor the prosecution, asked him anything about that at all. again, it put the defense in a very bad position to suggest that the defense could have asked without any idea what the real state of facts were, or should have asked, and that there was some onus on us to clear that up.
But nothing the judge said was incorrect, was it?
It's not incorrect, but it does suggest that in circumstances where no disclosure, because it was the court who gave the prosecution time to go away and find out whether this happened and to provide information. So the court was aware that nothing had come back as to whether or not that had happened. And then later suggested to the jury that the defense, could have asked Detective Redfern about that. I would have been, I would think, negligent in my duties to ask Detective Redfern about that without any information about what in fact had taken place.
Well, I'm not sure I agree with that, but that's neither here nor there. You could have asked Mr. Mahoney what the results of his researches were, did you?
Yes. And what the answer was, I'm not sure, it's possible that she may have done that. I'll get back to you.
And did you get back to him?
Nothing ever came to us, and the trial continued, and
it was all left dangling.
he never got back to us
I
again.
can interrupt, sir, but I can't recall Ms. Mulligan is purporting to quote me. Could she provide when all of that conversation occurred?
It was in court orally, and I can't provide the date.
Because normally on those things like those, it's my junior that Ms. Mulligan speak to in regards to disclosure and so forth.
Yeah, on this occasion, it was actually addressed before the court with the trial judge, and then there was a conversation with Mr. Mahoney, but I can't give you the exact date when it occurred.
Mm-hmm.
Further inherent difficulties with Ms. Card and Ms. Foley, particularly Ms. Card, because she was the one that provided slightly more detail about the actual alleged confession to the murder, is that the appellant told her he got him from behind. All of the evidence of the experts, Dr. Obafunwa, Dr. Milroy, and Jan Johnston, was that the perpetrator would have, in their view, been standing in front of the victim using his right hand to stab the victim on the left side of his body. Dr. Obafunwa made clear that it would not have been possible to inflict those injuries by reaching around. And the blood spatter evidence of Ms. Johnson suggested it happened near the front door, and the blood spatter went from the inside to the out, suggesting that the injuries were inflicted near the front door and the blood spatter went back out towards the patio area. There was at some point Ms. Card suggesting that, and I'll come to this in the court summation, but Ms. Card suggesting that he was stabbed in the back, but then she also said she didn't know how he was killed. So it came down to she maintained at the very least that Mr. Rogers said he got him from behind. And that is inconsistent with all the evidence at the scene. I don't know if your lordships wish to take a break at this point.
We do, but subject to two matters. Can you just help me? The first of them is this. You draw our attention in paragraph 36 to the fact that both ladies said that he hid behind the couch. Could we have a look at the photograph that appears at page 53 of the first volume of the Record of Appeal, which appears to have been page 43 of the trial photo album, which appears in the top right-hand corner. If you look at the photograph in a landscape orientation.
And that was one of the issues that we raised on the no case, that it was unlikely, at the very least, that anyone crouched behind that couch and managed to hurdle the plant and not disturb anything and come around to the front door and get in somehow in front of Mr. Gibbings to stab him from the front to the left side of the chest.
Yes.
So that was part of the argument made, that also led to the inherent unreliability of what it is alleged that Mr. Rogers told Miss Card.
Yes, I
And
follow
or
that.
Miss
Well, I
Fuller.
follow all that. What I'm not quite clear about is where the living room is. I assume it's on the ground floor.
Yes, if you go to the very next photo,
Yes.
you'll see there's a
Oh,
door
I see.
with a portion of the kitchen. So the main door is, let's see if I can find another photo. To orient you. All right, so you can see in photo 54, the table and chairs.
Yes.
And if you go to photo 21 and 22, you can see the same table and chairs there. So the living room was off the kitchen, certainly,
Right.
but not at the front door.
No.
The front door, if you look at photo 19, will orient you as to where the front door was, where that rug is, the welcome
Yes, I
mat, in relation to the table.
Sorry, that was 19?
Yes,
Yes. So in order to get from behind the couch to behind the getting in front of the person who's entering the door, you've got quite a hike.
yes. You can see again at photo 17, what Miss Johnson seemed to be saying, and I can certainly take you that after the break if need be, but is that around marker 4 is where the altercation started.
Yes.
And markers 3, 2, and 1 are indications of blood coming from inside the apartment out. So someone stabbing towards the victim,
Yeah.
or causing some injury that caused blood, and the blood spraying back out of the apartment.
Yes, I see.
And we know that the injuries were in the front of the victim.
So if he started off life at the couch, Mr. Rogers has got to get himself out and in front of the door.
Yes.
Right. That's question number 1.
Yes.
Question number 2.
I mean, more likely scenario. Yeah.
Question number 2 is this. At paragraph 31 of your submissions, you say that Katrina Card testified that when she saw him at 6 o'clock, she recalled that he was wearing a black long sleeve top, black track pants with 2 red stripes, and black and red Nike sneakers. He was still wearing the same clothes and footwear
Yes.
when he came back home and left again at 9. And you give a reference, transcript 12, 14 to 13, line 9. And, oh, I see. Yes, I'm so sorry. I had thought that those references applied only to the clothing, but they also refer to the black and red Nike sneakers. No, don't worry about that question.
Okay.
That is what was said. Thank you. Well, we'll take a 45-minute break now.
Thank you.
Just for the benefit of the members of the court, also counsel, the cloud has been updated, and on it you will now find the ruling in relation to the stay of proceedings, as well as the ruling for the abuse and no case applications. And the application submissions themselves have also been updated.
Thank you, Mr.
Thank you.
My
Very
lord,
good.
before you break for lunch, I should inform you that I did draft the
Yes.
document that you requested, and I've sent it to Mr. Coelho.
I've
And
received.
You've
Thank you.
received it.
Very good. Thank you very much. See you all in about 45 minutes' time.
Thank you.
think we're all here. Yes. We have made some marginal progress, but not enough. We have not yet discovered the ruling of Simmons J made on the 1st of July 2019 on the question of severance. We have found a note of the ruling made by Justice Attridge on the 15th of January 2020 on the abuse of process application made on behalf of Mr. Rogers. But the ruling reveals that reasons were to be given later. What it says is, whilst what is plainly in some form of note says is that whilst I am not in a position this morning with the panel assembled and awaiting jury's selection to set down my reasoning, I am in a position to communicate my decision. And he says, I don't consider, for the reasons that I shall provide in due course, that the application should be granted. Now that would appear to indicate that reasons were, or certainly due to be provided in due course. Whether they were in fact provided, we don't know. We would expect the parties who were present at the trial to know whether reasons were given, especially if there was a prospect of appealing against the decision. So I'm afraid I must urge all of you to see whether you can find the material which we miss, which is, as I say, the ruling of Justice Simmons and the reasons for the ruling of Acting Justice Attridge, which are matters from which you seek to appeal. Apart from that, everything's fine. Right, Ms. Mulligan.
Yes. Where I left off, I was discussing Ms. Carter and Ms. Foley. And I'd covered quite a bit of the issues that I say the court needed to be concerned about with respect to their evidence as to its inherent unreliability and collusion. There are a couple of things. I did refer to one case, which I know is not the same as this case. I'm not suggesting it is, but for principle, the case of Mackenzie.
Right.
And it is at page 4 of Mackenzie. I'm not sure if that can be brought up.
Where is it?
The site is 1993 1 WLR 453, 1992. Yes. And on page 4 of that decision, the paragraph beginning with nevertheless. This case was clearly not the same in that it was a confession by a mentally handicapped person given to the police. So we knew that the person had actually said it, but the court was concerned about the reliability of it and therefore whether it should be withdrawn from the jury. I don't cite it because it's the same. It's not the same. But if we look at that paragraph, there are some principles that I'm going to ask the court to consider in relation to these two witnesses' evidence. The court says, nevertheless, applying the guidance given by this court in Galbraith, we consider that where the prosecution case depends wholly upon confessions, and that was certainly this case, the second category there doesn't apply. The defendant suffers from a significant degree of mental handicap. And 3, the confessions are unconvincing to a point where the jury properly directed could not properly convict upon them. then the judge, assuming he has not excluded the confessions earlier, should withdraw the case from the jury. Court goes on to say confessions may be unconvincing, for example, because they lack the incriminating details to be expected of a guilty and willing confessor, or because they are inconsistent with other evidence, or because they are otherwise inherently improbable. Cases depending solely on mainly on confessions, like cases depending upon identification evidence, have given rise to miscarriages of justice. So, while it's not the same, I say some of those same factors apply here, in that it lacks detail, the two confessions. You would think if he was confessing to this terrible crime, the most burning thing on his mind would not be that he hid behind the couch. It's improbable, and that the physical evidence at the scene doesn't seem to marry up with that. The evidence of Miss Card, initially to the police, and this was covered in her cross-examination, which I've set out in my submissions. Initially, the police said that Cleveland said he stabbed the man in the back. And in her evidence, she said, well, he said he got him from behind. Both of which are inconsistent with the evidence at trial. It boggles the mind that years apart, the appellant would somehow confess to his two intimate lovers, the women in his life, and either lie to them about these few details that he was willing to share, or was mistaken in exactly the same way. It makes no sense. It makes no sense that they took no action. They continued their relationship if, in fact, the confessions happened. There was also the issue with respect to these two witnesses that was raised with the court when considering whether or not their evidence should be excluded or the charges stayed, or even the no case submission. Extraordinary meeting with the police, for which there were no notes, but after which Miss Foley gave a correcting statement, correcting her evidence about at least the timing of her relationship to be consistent with Miss Card's. That meeting took place, it was an hour and a half long, I believe, or an hour and 10 minutes long. And there were no notes taken of the contents. Two key witnesses.
Which meeting? Which meeting are we referring to?
This was a meeting with the police. Let me just get you the date.
The police sent who?
Miss Foley and Miss Card together. And that case can come down now. That'll assist me so I can get to my other material. Thank you.
I've got a note of a meeting on the 9th of August 2018. Is that what we're talking about?
That was it. Yes. I'm just looking for the exact time. One moment, please. Okay, so. All right. So that meeting takes place, yes, on yes, August 9th, 2018, between 12 p.m. and 1:10 p.m. Daniel Foley, Katrina Card, Detective Inspector Redfern, and DC Sabian. And the note made by Detective Sergeant Martin, who was also present, says only serious crime unit meet with Danielle Foley and Katrina Card, interview DI Redfern and DC Sabian re Marcus Gibbons murder. The next note is 1310, 110 meeting.
Ms. Mulligan, are you reading from somewhere that we also can locate?
I don't think it's in the records. The notes made by DS Martin, and I'm not sure that you have them, but there's no content to them. It just says there was this meeting, and at 1:10 it ends, so an hour and 10 minutes later, and there's no content as to what was discussed.
So
But
where
we
does that?
know that's August 9th, 2018. But we know that after that meeting, Ms. Foley gave her statement correcting the dates that she was in a relationship with Mr. Rogers. So we don't know what else might have been discussed as between the two of them. There's no record of that meeting other than that. Which is wholly unsatisfactory. I mean, these are experienced officers who.
Well, were they asked at the trial what had happened?
Yes, they were. And although they could not tell us everything that was said in an hour and 10-minute long meeting, their answers were basically that they were discussing concerns about safety, primarily. Just have a moment, see if I can see if any of those transcripts have been produced. Does not appear that they have been, but the officers said they were discussing concerns about safety primarily, but yet there was no explanation as to how it was that immediately on the heels of that interview or that meeting, Ms. Foley made a statement correcting factual matters.
But Ms. Mulligan, I mean, you're making submissions in regard to this meeting. You refer to the officers who were present, and if you had thought that there was anything of benefit to the court in relation to the evidence of those officers, I would expect you would have asked that they be transcribed, as indeed Chief Inspector Cardwell's evidence was transcribed.
Well, I suppose I didn't think there was anything of benefit because none of them could say really everything that was said in an hour and 10-minute long meeting some years earlier. That's
so there's not a lot of point in carrying on about the point, is there?
Well, that may be. I guess my point is that they had a duty to preserve that whatever happened there with the two main witnesses against my client who were claiming he confessed. They had a duty to preserve in some way.
To preserve what? There were no notes taken. You've said that.
Yes, they had a duty to either take notes or record the meeting. In my respectful submission, because now we don't know what happened and there's a risk. It's at least an inference to be drawn that some facts were disclosed.
If you're going to suggest to them, the officers, that is, that they had behaved improperly, I would expect to see cross-examination on that, and I would expect to see a transcript of that cross-examination.
Yes, and it should have been provided, you're right. So at the end of the day, I have set out in that section, underground 2, all of the areas that I say that there were either inherent inconsistencies, unreliability, inconsistencies with the evidence, weakness, vagueness. It ties in with the insufficient warning ground, and perhaps that's where I should go next. That not only did the court not exclude their evidence or stop the proceedings, given that their evidence was the only evidence upon which a jury would be asked to rely or could rely against Mr. Rogers. But having not done so, then the warning given to the jury and the instructions to the jury about their evidence ought to have been much stronger, and it was not. I begin that ground at page 26 of my submissions. Before going there, I should just stop for one moment. I know that I had said I didn't put in much in my submissions about this Miss Card saying that Mr. Rogers said he was to be paid and he was getting paid, or that he told her it was for odd jobs, but she knew in her mind that it was for the murder. My friend has put, Mr. Mahoney has put in his submissions, because I said there's no evidence that she had done anything unusual, Miss Burgess, to pay him, or that he had received any money other than that. I note at page 15 of my friend Mr. Mahoney's submissions that there is a reference to Miss Burgess's Bank of Bermuda account records. And it says it revealed that on the day after the murder, she withdrew $2,000 from the Express Banking Center, and her average account balance was rarely over $200.
Well, that doesn't seem to be a very good point, because from what I've seen of the bank statements, that was her habit to draw
Exactly.
out £2,000 just after her salary check had gone in.
Yes, and that was my only point on that, that even the trial judge didn't even speak to the jury about that because it was meaningless, that she had done it for months and months since the beginning of the year. All right, so I can move on to the insufficient warning. What did the judge actually say about these witnesses if the court finds that they could be left to the jury? With respect to the evidence of Daniel Foley, this is at in general, that the court should have warned them there was a danger, was concern about this evidence, based on the fact that we have one witness saying, yes, she told me this detail, and I told the police that Mr. Rogers actually said it, but I've changed my mind. And the other witness saying, we didn't discuss the details. There was clearly concern about how their evidence came to be. I say, in addition, the meeting with the police that was unusual. But none of that was really pointed out. My friend in his submissions, Mr. Mahoney, says that we weren't relying on collusion. We clearly were, and the trial judge did say that we had concerns that they had colluded. With respect to the evidence of Daniel Foley, I've covered the point that she says that that at first Mr. Burgess or Mr. Rogers told her he hid behind the couch. The trial judge, in fact, in his summation, is 412 to 413, tries to address that, and my submission does not go nearly far enough. If we go to the summation, and I think I was here just a little earlier, but just on this point, the judge doesn't make the point that we were asking to be made, that we had made in our argument and trying to make in before the jury, that this was evidence of collusion. What we see at page 412 at line 10 is the agreement that she had told the police in her statement that Mr. Rogers told her that he had crouched down behind the couch. She accepted that was incorrect. Well, in fact, she just simply changed her evidence at trial and said that Katrina Card had told her that and not Mr. Rogers. Court says, again, you'll consider with perhaps the fact that Miss Card said she did not tell Miss Foley any of the details of what she says Mr. Rogers told her. I don't think I need to remind you, though, of how you are to approach inconsistencies and discrepancies that you may find exist within the evidence you've heard in this case. Well, in my respectful submission, this wasn't just an inconsistency or a discrepancy in the usual course. This was clear evidence that the two women had discussed the matter, that initially Miss Foley had not told the truth to the police, about where she got the information. She said it came from Mr. Rogers, significantly said it came from Mr. Rogers, that he confessed that he was hiding behind the couch, and then changed her evidence at trial. But Ms. Card maintained that she hadn't discussed that.
I still don't get your reference to collusion, but we've been over
Ms.
that before.
Foley denied, however, that all the information. Well, clearly, Ms. Card told, according to Ms. Foley, by the time of trial, Ms. Card told her that Mr. Rogers had told Ms. Card that he hid behind the couch.
Pausing there. Collusion is an agreement where two people discuss and agree on their evidence. Here we've got an example where there's a conflict between what Ms. Card says and what Ms. Foley says.
It wasn't initially, right? Ms. Foley and Ms. Card both went to the police at roughly the same time and gave interviews saying, Mr. Rogers told me that he hid behind the couch. Both of them said exactly the same thing. Mr. Rogers said it. I don't know why Ms. Foley changed her mind about attributing that to Mr. Rogers by the time of trial.
But if they were in collusion, you would expect them not to change.
What we do know is that she did. Well, you would expect them not to, and you can see that Ms. Card clearly didn't know that Ms. Foley, by the time of trial at least, was going to change that bit of the evidence and attribute it to her, because Ms. Card maintained throughout she never had that discussion with Ms. Foley. So that is some evidence of a lie covering up a discussion that she in fact had with Ms. Foley. What would be the reason for that other than the fact that they colluded? I ask rhetorically. I mean, why would you lie?
Ms. Mulligan, if they did collude, they didn't do it very well because they didn't reach a consensus, did they?
Not by the time of trial. Certainly at the time when the police relied on them for charging Mr. Rogers, they did. The one burning detail of hiding behind the couch came from Mr. Rogers. Both of them. By the time of trial, as I say, I don't know, maybe they had act of conscience to some extent, to some degree, but Ms. Card maintained and continued to maintain that they never discussed it. It can't be true. Both things can't be true. And the
jury had all this before them.
The jury did have all this before them, but it is an unusual kind of case where we have the entire case depending on two witnesses with an axe to grind who have clearly discussed the evidence, even though one is maintaining they haven't. And the judge says to them, well, it's just the normal thing of inconsistencies and discrepancies. Doesn't give them any more strong warning about relying on this evidence. Doesn't, and I'll come to this, doesn't really give them much warning about the fact that it's inconsistent with what happened at the scene for the rest of the Crown's case. These are the kinds of witnesses that it would be potentially dangerous to rely upon unless their evidence was in some way corroborated, not by each other, but by something. And it's not. In fact, it's out of line with the evidence that we know is at least reliable. And he doesn't say that. He doesn't give them any kind of help with that. He just says, I don't need to remind you about how to approach inconsistencies or discrepancies. The court goes on to say Ms. Foley denied, however, that all the information she gave to the police came from Ms. Card. She later added that she should have corrected the police, and that's the part about there should have been some correcting statement. With respect, this evidence doesn't highlight the significance of the witnesses' failure to be honest about their discussions before the jury. It should lead the court to say, well, there's some concern about what discussions they had. And that Ms. Card, therefore, if they accept that Ms. Foley says she had those discussions and got that information from Ms. Card, then the jury should have been pointed out to them. Then Ms. Card, if you accept that, Ms. Card has told you a significant lie, has sat before you and told you a significant lie, if you accept what Ms. Foley says.
where is the point in Miss Foley's evidence, or indeed Miss Card's evidence, of discussion between the two of them?
Miss Foley's evidence. Give me one moment. Well, Miss Card's evidence, I think it's at page 1 of Miss Card. It's at 178, I believe. I'll just turn it up.
That's Mr. Mahoney's re-examination.
Okay, so it had to have happened earlier as well, but just a moment. Yeah, you can see there that in re-examination, at least at 178, line 10. Now, in respect of, did you ever have any discussions with Miss Foley, re Rogers, and the murder of Marcus Givings? No. No? In answer to Mr. Daniels, you said that Miss Foley and you were discussing, and you said not particulars. What you meant by not particulars? I didn't tell her everything I knew. Okay. I didn't tell her everything I knew. Knew about what? The murder. Did you tell her anything you knew? No. Did she say anything to you about the murder at that time? Over time we talked. Over time we talked. So at what particular point in time the murder came up? I just said he needs to pay for his sins. I said everything's coming back to haunt him. That's when she said that she knew what he had done. Did you know what she was talking about? I did. How did you know what she was talking about? Because I was with him then. Because I knew everything already.
I don't think this takes us anywhere. Is there anything that's on point in the cross-examination by Mr. Daniels?
Yes.
I mean, this, if anything, undermines your submission that she lied about not talking to Foley. She's admitting she did over a period of time.
Just didn't tell her everything she knew.
Yeah.
None of the particulars.
I thought there was a passage where she said she didn't discuss the details, but
Was that at 152, Card is being questioned by Mr. Daniels about her discussions with Foley?
That was after they initially talked about his daughter. So that wasn't about the murder. That was just as they were getting to know one another. Okay. The other interesting thing is that at page 156, line 8, she says she had told the police officers in her interview at page 119 that Danielle was aware that you'd gone to Crime Stoppers people in 2015, correct? Danielle Foley actually says she wasn't aware of that. And you made it clear that you and Danielle had been discussing, and Ms. Card interjects, not particulars. Pardon me, not particulars. No, but you and Danielle had particulars. That's very funny, but not particulars. No, just curious. try and not make comments. I'm sorry, my lord. If we go to the next page, line 157, or page 157, line 8. With respect to Danielle, you shared with her basically all of what you've shared with us. Answer, no. And you've described how you and Daniel became friends. That goes on. And I don't know as it comes up again until the re-examination, but
It doesn't really take us very far, does it?
well, just that she says she didn't discuss the particulars
Oh,
of
it's
what.
doubtful it's dubious what she means by particulars.
Well,
Especially when re-examination, she says she didn't tell her everything.
well, she only had a few particulars. Let's be clear. I mean, the entire confession is, I hid behind the couch. I got him from behind.
Well, but Ms. Mulligan, you keep referring to that. That's why I asked you to take us to the discussion between Card and Foley in relation to this matters, insofar as it came out in the evidence. And you haven't taken us to anything yet.
Well, I guess that was my understanding of her evidence, was that she hadn't discussed the particulars. She hadn't talked to her about it. And then in re-examination, it was cleared up that when she did speak to her about it, it was just to say that they both knew what he'd done and that he needed to pay for his sins. So I don't know as I can help you further than that, and that's the evidence. Ms. Foley says that she got this information from Ms. Card. It would have been a particular, one would have thought, hiding behind the couch. But there's no warning given to the jury by the judge about how to deal with these two witnesses. Not even a warning given that they had an interest to serve, they had a motive, they wanted to keep him in custody, that they became friends over the years even. It's more, you can deal with them the same way you deal with all other evidence. And in my respectful submission, that wasn't sufficient with these two witnesses. You will see that even where the witnesses have, in my respectful submission, said something that's totally inconsistent with the evidence, the court has not cautioned the jury about accepting their evidence, but tried to explain it away. This comes in at the point about getting him from behind or stabbing him from behind. If we look at the transcript of Katrina Card at page 71, I'll take you to a couple references. Page 71, you'll see that Mr. Daniels is questioning her about her statement to the police. And you'll see that she's told them, the witness, yeah, I told him, meaning the police, it was a TV stand, a black TV stand. Then he killed the guy using one of the knives. And then he goes on to say, and you described that Clevey stabbed him in the back. Answer, well, he did get him from behind because he kept saying, what did I do? What did I do wrong? The question is whether you told the police that Mr. Daniels stabbed him in the back, the witness correct. You all suggest, I'm going to suggest, then you describe the knife potentially as a dagger, and it goes on. If we go to pages 160 to 161.
Just before you go on, I mean, on 72, line 16, she says, in answer to Mr. Daniels, you also shared with the officers that you and Danielle Foley had discussed Rogers and the murder. Answer, yes. But then Mr. Daniels doesn't follow it up and find out what they actually did discuss.
Yeah, it doesn't appear that he did there. I agree.
So you're taking us to 160.
160, page 160 of Daniel, or of Katrina Card's evidence.
Let's go back to 71. It's not a curious this. It's put to her, and you describe that Cleeve stabs him in the back. Well, he did get him from behind because he kept saying, what did I do? What did I do wrong? That appears to be taken literally, an inference on her part that because he kept saying, what did I do wrong? He must have been stabbed in the back. So you can conclusion doesn't follow from the premise.
That wasn't the way she put it to the police. I don't know why. No, I don't know why she answered in that way. She tended to want to get a lot of information out before the jury. If you read through the transcript, sometimes not very responsive. Because we go to page 160.
Thank you.
At line 20, Mr. Daniels comes back to that, I believe. Line 20. Now, just to be clear, in relation to these so-called details of the murder, you're saying that out of what he shared with was, one, that he hid behind a couch, correct? And two, he stabbed him in the back. Answer, correct? And what he said, sorry, and what the victim said.
Where are we now?
Mr. Sorry, page 160, line 20. 160.
Right, thank you.
So the details of the murder, he hid behind the couch, correct? Page 161, and two, he stabbed him in the back, correct? And what he said, sorry, and what the victim said. Sorry that he was, sorry, just crave your indulgence. So again, she's trying to get all those three details out at the same time, my lord. She's saying, yeah, those were the three things. He hid behind the couch, he stabbed him in the back, and the victim said, what I do wrong, what I do wrong. And then at line 14 on 161, in terms of the interview, and I'm just trying to find this page, so I'm having a little difficulty at the moment, but during the course of the interview, Cleeve got him from behind, correct? Where are you now? This is why I'm trying to get myself in order. At line 7 of 162, okay, you were describing in that interview that he got him from behind and he meant Cleeve, right? Line 29, correct. And then you said he closed the door. I mean, it's a minor point, but the door was open when the first responders arrived, when they first found, or when the friends first found Mr. Gibbings. And then you said he closed the door, correct? And that's where you're saying Cleeve told you, no, I just know he got him from behind. So I don't know what you make of that. I know that, you know, the transcript of the police, she said he stabbed him in the back. She seemed to agree with that. And then she said he got him from behind.
Well, I mean, one of the problems was that Mr. Daniels seems to have equated got him from behind with stabbing in the back, and then persuaded Ms. Card to agree that he stabbed him in the back, when it's not what she had originally said.
I don't think that's right. I think she had in fact said to the police that he stabbed him in the back, but she also used the words got him from behind.
Well, they're two different things, aren't they?
Well, yes, or two parts of the same thing, but yes.
They're two different things. Just because you attack someone from behind doesn't mean to say you actually stab them in the back.
Yes. But it's put to her very clearly at the outset that she said to the police that he stabbed him in the back, and she agreed with that. She also said to the police that he got him from behind, and she agreed with that. The court deals with that in its summation. In my respectful submission, it treated it as nothing more than semantics, and in my submission, it was a very important point, had to be treated differently. And that's at page 395. At page 395, the court says, at line 13, Ms. Card then confirmed that the detail that Mr. Rogers shared with her about the murder was that he hid behind the couch, that he stabbed Marcus Gibbings in the back, which you know is not true, and what the victim said. She was then referred to her June 28th, 2018 statement to the police and confirmed that she told the police that Mr. Rogers got him, meaning Marcus, from behind. So you might think that there's a distinction there between what she was saying to the police, that in fact means stabbed him in the back. And she also indicated in the statement that he closed the door. Ms. Card said that Mr. Rogers did not tell her that he closed the door. She said that she just knows Mr. Rogers got him from behind. So that's all that was said about that to the jury. And in my respectful submission, it's significant. These are very few details, as was pointed out, that these witnesses are giving in a confession, and some of them are clearly wrong. They're not consistent with the evidence. The jury ought to have been warned that where they found other evidence suggesting that the details being given were wrong, that they may well find one of two things: either that the account given by Ms. Card and Ms. Foley was unreliable, or that they're lying. And I've heard the court on my point about collusion, but I maintain that it is there, and ask the court to consider it.
The judge did remind the jury on page 394 that the defense case included an allegation of collusion.
Yes, but that's not the same as giving them any instructions about that. The defense says there was collusion. You could look to this evidence or that evidence.
But that was the problem. There was no evidence of collusion.
Well, I guess it depends how you look at the evidence. In our respectful submission, there was. You get to determine whether or not, when Ms. Card said that she didn't discuss the particulars of the murder or the particulars of what Clevey said with Ms. Foley, and Ms. Foley said that she got the particular about the couch from Ms. Card, whether in fact that was some evidence of collusion, whether the fact that Ms. Foley initially...
How can it be evidence? How can it be evidence of collusion when Ms. Card says something different?
They both initially said the same thing. That's my point. They both initially said to the police that Cleveland Rogers told them, each of them individually, years apart, that he hid behind the couch.
Right. So that collusion, we're talking about discussion that's between Card and Foley.
Yes. Miss
And you
Foley,
still haven't taken us to where they have agreed in some way to tailor their evidence in furtherance of some common purpose.
well, I wish I had them saying we agreed to tailor our evidence. I don't have. What I have is Miss Foley saying, yes, although I told the police that Mr. Rogers told me that, he told me hid
In fact,
behind.
it was Miss Card who did, and Miss
Yeah.
Card says it wasn't. The very
That's a-
opposite of collusion.
Well, it to use Mr. Richardson's phrase, it kind of beggars belief that Miss Foley could possibly innocently make that mistake in her initial police statement, to say that I remember she's only there to talk about the confession from Mr. Rogers. That's her whole purpose. I remember Mr. Rogers confessed to me. He said he killed him. He said he hid behind the couch. He said he was crouched down. It is hard to imagine that Miss Foley, having come to the police only days after Miss Card went, giving that detail as coming from Cleveland Rod, and later admitting it came from Miss Card, that she just got it wrong. That's her sole purpose for being there, is to say what Cleveland Rogers told her, but she just somehow got that wrong, as opposed to Miss Card had convinced her to tell the police that story.
There's no evidence of that at all. So, I mean, I don't think you can make that as a submission.
All right. I just don't know how else it could possibly happen. And that's I guess my submission, is that how else could it possibly have happened? In any sensible sort of analysis of it. And then to Dr. Obafunwa, which is also part of the abuse application. But it was a separate issue as to whether he should have been permitted to give his new opinion, or whether the trial should have been mistried. Dr. Obafunwa had done his initial autopsy report in 2006.
Wait. Can you wait whilst I see your question?
Sure.
Which ground of your appeal are we now on?
We're in a couple different areas. The ground 3, the learned trial judge erred in permitting the prosecution to rely on the very late and new opinions of Dr. Obafunwa, some of which were heard during the first time in evidence.
Right.
Clearly, this had not happened at the time when the abuse application was made, but I would submit as something that the court could consider as its ongoing duty to ensure that the trial could still be fair. Dr. Obafunwa, the details about his evidence are set out in my submissions beginning at page 7. And again, I think I returned to it. Maybe I don't. Yes, at page 22. So it's set out in 2 different places. Dr. Obafunwa wrote his autopsy report in December 2006 and was not asked to sort of revisit it in any way until June 2018. And that you will have seen in the evidence, Inspector Redfern sent him a photograph of a knife and asked in the email if the knife in the photograph could have been used to make the injuries to the victim.
And can we just be clear which knife he was sent?
Yes.
Is it the one at page 477?
Let's have a look.
Volume 2 of the Record of Appeal.
Yes. Now that was a photograph that Inspector Redfern had picked off the internet.
Yeah.
And shown to Ms. Card, and Ms. Card's evidence about that I can take you to so that it's clear.
So is the position that by this time, Miss Card had described the disappearing knife, and now Inspector Redfern was showing her a sample of a knife which he'd downloaded?
Yes.
Yeah.
And she said in her evidence at page 77 and 78, she described that in cross-examination, what happened. She said, this was prior to her interview. At line 16, Mr. Daniels asked, and before you got into the interview, he, meaning Mr. Redfern, wanted to explore with you what this knife looked like. Yes? And she said, an idea. Question, yeah, he wanted to get an idea. And so he pulled up on a computer images of knives. Answer, correct. And showed them to you, correct. Question, with a view for you to look at the knives and select something. Answer, but it was nothing like that. It wasn't like what he pulled up. The knife weren't exactly like what he pulled up. Can I just finish my questions? Okay. Mr. Mahoney, can we get the answer? There's some discussion between the court and counsel. And then over on page, the next time comes up is page 79. And he talks about having sat down with the police, but I think that's probably where it ends. Oh, at page 80. For example, at line 5, they said, look, let's look on the computer screen and see if we can find a knife. Yeah. Mm-hmm. And then after that, you had selected an image that looks similar, as you say. Yeah, correct. And then went over to with the officers to Hamilton Police Station. I'm sorry, sir, Mr. Mahoney. How can he say she said it looks similar based on what she said, sir? I'll get the evidence. I think that was a suggestion being put to her and she agreed with it. And I'm not sure it gets back to after that, but it seems initially, at least she said, it wasn't exactly like that. It weren't like that.
Well, she started off by saying it was nothing like that.
Yes.
And he said it wasn't exactly like what he pulled up. And then there's a lot of flapping around with questions which go nowhere. And then it's put to her, then after you had selected an image that looked similar, you, as you say, yeah, correct, you then went over to the police station. So in effect, Mr. Daniels put words into her mouth.
Yeah. I would agree with that. I think her initial answer was that it wasn't, at least not exactly like what he pulled up, or wasn't like what he pulled up. And that was the image that you've pointed out on page 477. So that's the image that is sent to Dr. Obafunwa in 2018 and asked if the knife, if that knife could have been used to make the injuries. According to Dr. Obafunwa, he told Inspector Redfern over the phone that he could offer no opinion because he didn't have the dimensions of the knife.
Yeah.
So that was the next contact he had with the case. He then comes to testify, and he meets with the prosecution and police on February 9th. And he's due to testify on the 10th of February 2020. 9:12 a.m. on the 10th of February 2020, his new statement, or a new statement from him, was emailed to defense counsel. The statement dated the 9th, but it was emailed on the 10th, just before we entered court. And a notice of additional evidence number 16 was filed. And the statement was very short. It is set out in its entirety somewhere in my submissions.
The part that matters is, having reviewed the photographs of the injuries, it is possible that a single weapon having both a serrated and straight sides could have produced the injury seen.
Yes. So that was not set out in that manner in his autopsy report. But this was provided to us in the morning he was to give evidence. So and we asked that at the very least, we be permitted to meet with Dr. Obafanwa and find out what it was that this meant. Because it was a very, very short statement. And you will see on page 478, Dr. Obafanwa did meet with the defense. It's not entirely true that there was no representative from the prosecution there. Ms. King did arrive. I don't think she was there the whole time, though. I think she arrived a bit late. But in answer to questions about what his statement meant, Dr. Obafanwa drew two knives. You will see that one of them in page 478 is one that appears to have a serrated edge and a straight edge, which would seem to be consistent with his statement of February 9th, that it was possible such a weapon could make the injuries. The other knife he drew is one with two serrated edges from the tip going down to somewhere before the handle starts and becoming smooth. That particular drawing would be consistent with Miss Card's evidence that it had two serrated edges starting at the tip and going down to somewhere just before the handle. That double serrated type of knife, which you'll find as we go through the evidence, neither Dr. Milroy nor Dr. Obafanwa had ever encountered, was not consistent with even the statement provided that morning by Dr. Obafanwa. That isn't what his statement said.
Have we got that statement?
I don't know as you do, but it was repeated line for line. It was only like 2 lines long in his...
Mr. Mahoney's bundle.
Yes, tab 11.
Ah, thank you. Thank you.
Oh, yes. Sorry, I only got that yesterday.
So you will see it says his name, who he is, and then
Yeah.
he performed the autopsy and he'd like to make a statement in addition to his report. Having reviewed the photographs of the injuries, it is possible that a single weapon having both a serrated and straight sides could have produced the injuries seen.
Yep.
But somehow, having never seen a weapon with 2 serrated sides from the tip, he nevertheless drew this drawing. That led to some consternation on the part of the defense, because we didn't know what he was going to say really about that. And so there was some discussion with the court about what to do now that we have this new opinion. There was, the matter was, well, we sought a mistrial couple times in relation to Dr. Obafunwa. That was not granted, and the matter was adjourned. Dr. Obafunwa went away. I believe he went back for a few days and returned. In the interim, we asked for either a mistrial or that Dr. Obafunwa's new opinion be excluded, it being unclear exactly what it was given the two drawings. The court denied either, but said he would give us some time to consult our own expert, if we could locate one, retain one, and provide all the materials to him. Dr. Obafunwa came back. I'm just gonna get the dates.
Could you just tell me before you do that, if you look at your submissions on page 8, you say at E, the defense asked for the following relief: 1, that Dr. Obafunwa not be permitted to give this evidence, or 2, that the case be mistried as a result of the new expert opinion evidence. Is that after you had, that in F, you described the meeting that you had with him? Should we understand, in fact, that the application referred to in E followed the meeting in F?
No, sorry, and it's not clear in my submissions, and I apologize. My recollection of it is that we had the meeting. We felt that we could proceed, but then it became very clear in Dr. Obafunwa's evidence that he was offering not just that new opinion, but myriad new opinions.
So is the position still not clear that he started giving evidence, and in the course of it, you asked for the relief in E?
Yes.
Right.
And you'll see that, if I may. It doesn't, the submissions aren't set out, but there is, I do say at the end of his evidence in chief, an issue arises. And let me just find. That point, because the court does speak to it.
Oh, I see.
Because it was not only this particular issue where he's now not only saying a single serrated edge knife, but now maybe a double serrated edge knife. He also wanted to opine, or the Crown wanted him to opine on a number of photos that the Crown had not been relying on before and indicated they weren't relying on, and wanted to give opinion evidence about seeing injuries consistent with a double serrated knife, none of which appeared in his report from 2006. So you will find
in his report in 2006, he didn't go into the nature of the weapon that had caused the damage at all, did he?
he did, well, no, he went into the nature of the injuries.
Right, not the nature of the weapon.
No, and on one occasion, he mentioned that one of the injuries appeared to have a serrated edge. But he wasn't, I assume he wasn't asked anything further about the nature of the weapon. Now, you'll see at page 28 to 29.
Of what?
Sorry, Dr. Obafunwa's evidence. Because a number of new opinions sort of emerged as he was giving his evidence. And this was on February 12th. So 2 days after the defense has received this new statement and the drawing.
Sorry, what page did you say, Miss Mulligan?
Page well, we can start at page 27, I guess, of his evidence.
Thank you.
He is asked there at line 11, and in terms of a weapon, this is by Mr. Mahoney, what kind of weapon? I came to the conclusion that it has to be a knife with serrated margins, particularly close to the tip. And why did I say close to the tip? When you look, if we remember that I mentioned some superficial incised wounds that were not so deep, it showed serrations, so it has to be close to the tip. I mentioned a blunt end in my earlier presentation. That bruise due to the blunt end, like I said, could have come close to the point of the termination of the blade. So on the there could be delay. I think in my report I made mention of a single edge, which he did. Yes. Answer, when you look at the injuries that I showed, of course, that single edge blade that I mentioned, this is Dr. Rafun again, he's answering nothing, is because of that blunting in the very simplistic sense. But if you imagine a blade with serrations, particularly close to the tip, some blunting there, a knife with that kind of configuration could have been used. Could there be any other blade? Possible, I wasn't there. That is a second blade, but one weapon with the kind of configuration I described is capable of producing the injuries. Thank you, doctor. I say I believe an issue arises. All of that being quite detailed new opinions about the nature of the weapon or weapons. So again, the submissions there that the matter can't be resolved. There should be a mistrial at that stage because we can't deal with it. And what the court says, the best way to resolve this currently, as I see it, is to cross-examine him based upon the instructions you've had from your expert and the information you have before you, Ms. Mulligan. At that point, I had already undertaken to try and get some information, speak to an expert of my own to deal with the statement, the new statement that Dr. Oberfunwa had made on February 9th. But the evidence went much further than what was in that statement, obviously. And it became, in my respectful submission, impossible for counsel in mid-murder trial to deal with this type of evidence on the fly. As I indicated previously, and you don't have what was indicated previously, but as I indicated previously, you can highlight what you say is information that's not contained anywhere in his report that he's provided so far, and indicate to him that, which as I say, I anticipate he will accept, that you therefore are not in a position to respond to those matters in cross-examination, but will seek to try and do so in some other manner. Well, that's not, in my respectful submission, that wasn't very satisfactory. We should have been able to respond to those issues in cross-examination. Expert reports should be provided in plenty of time. Expert opinions, if they're changing or if there's going to be something additional offered, should be provided well before the trial, not near the end of the Crown's case. And then we're going to have to, if necessary, give you more time in order to call your own expert. So deal with the cross as best you can based on what you have, what you know. But if you can't deal with it properly in cross, you're your own expert. And if you also seek to recall Dr. Obafunwa, if it's considered necessary, then we can consider doing that also. But let's proceed to do what we can this afternoon. With the greatest respect, there isn't a chance that I would ever consider recalling Dr. Obafunwa. He was the most difficult, one of the most difficult expert witnesses in my 27 years that I've ever cross-examined. He did not directly answer questions for me and was very, very difficult, wanted to give his own information, which made it even more important that we had a proper opportunity to cross-examine him, to prepare for that cross-examination and not be taking instructions. This was only 2 days after we received that one-line statement, and then on the same day that he's offering all these new opinions, that we had never heard before, I'm told to just cross-examine him as best I can and call my own expert. And I tried to do that. I wouldn't say it was terribly successful, because in part, I didn't have the fullness of time to consider the new opinions and to speak to the expert, but also his manner of giving evidence. His evidence was changing throughout and it got stronger. The more I asked him questions, the more difficult and more strong he became, that it must have been a double serrated edged knife with serrations near the tip.
Where does he say double edged? No doubt that comes in his evidence. It's not in his written statement, and I've been looking at the original autopsy report from 2006, and you said that he'd referred to serrations. I couldn't see any reference to serrations in that original.
In one paragraph, he refers once to serration, and if I can find it. Is it in the record of appeal? I'm sorry.
No, I have it. It's provided by Mr. Mahoney, confusingly with his authorities at tab 10.
I knew I'd seen it recently somewhere. All right. So the only mention if I recall, it was in the description. At page 269 at the top, or page 13 of his report.
Yes, serrated.
268.
So with respect to 3 wounds, the serrated appearance of wounds 13, 18, and the long arm of 6 will suggest the use of a blade which is serrated with intervals of 4 to 5 millimeters. The fact that wounds 9, 11, and 12 shows a single blunt margin, which are medially directed, will suggest a single-edged blade as having been used. Furthermore, while the length of the blade, and he goes on,
Miss Mulligan, unfortunately, my tab 10 stops at page 268 or page 12 of the report. How many more pages are there?
it just goes to 269. So you're missing the last page.
Could somebody send it to me, please?
And it's the first line at the top of 269.
Right.
To be clear, I mean, when we read this, one with relation to 3 injuries, he talks about a serrated appearance. In relation to 3 others, he talks about a single blunt margin, suggesting a single-edged blade as having been used. There was some discussion with the doctor as to whether he meant 2 different weapons or 1 weapon, because it wasn't necessarily clear from this. But certainly there's no mention anywhere in his report of a weapon with double serrated edges to the tip, or even double serrated edges. But that becomes his opinion. First,
He doesn't use the phrase double in relation to serration, does he?
no, never. Not in his report. the first time we hear anything like that from Dr. Obafunwa is on in his February 9th statement. No, not in his statement, sorry, in the follow-up, where he draws the picture. That's the first time that he gives any indication that he has any opinion about it being a double-edged serrated knife. And you see he gets stronger and stronger in that in his evidence as I ask him questions. The other, as I say, the other issue that came up is that he insisted that he should be shown more photographs than what the Crown had intended to rely upon. This is all happening mid-trial, and give more opinions about and show where he said they were double-edged serrated. And show where he said there were double-edged serrated marks. All of this coming.
I've lost you, Miss Mulligan.
Sorry.
That's better.
Okay, thank you. He was also, the Crown served upon us notice that they would be relying on not new photographs, but photographs other than the ones they had advised they would be relying on. Obafunwa, to be fair to the prosecution, felt that he could best show these double serrations if he could show other photographs to the jury. All of which, as you can see, I'm trying to deal with in cross-examination in the middle of this trial.
I'm a little lost as to exactly what happened. You said a moment ago that the judge had said that if necessary, Mr. Obafunwa could be recalled. And you said that that was the last thing in the world that you want to do, since he's a very difficult witness to cross-examine and kept on getting stronger and stronger the more you asked him questions. But if one looks at tab 16 of volume 2 of the transcripts, Professor Obafunwa appears to have been cross-examined by you on Wednesday, the 12th of February, and then cross-examined again for another 50 pages on Tuesday, the 18th of February.
Yes.
And you'd been advised by Dr. Milroy in between.
Yes, let me be clear what happened. So as the professor continued to give new opinions, again, in answer to questions that I'm asking on my feet, I asked again for more time, that now there are even more new opinions to deal with.
Right.
And so I was given a bit more time. I did ask again for a mistrial, don't get me wrong. Did not get that, but was told I could have more time to consult my own expert. But we're not talking about the kind of time one would want when confronted with this type of evidence, with an expert who's in another country, who has to be flown in ultimately, but not during this time, to give his evidence. It was, I suppose another counsel perhaps could have dealt with it better, but I must confess that I found it a very unfair and unfortunate circumstance to have to deal with this kind of evidence in this manner during the trial.
When everybody had jumped through their various hoops, there were two experts, the one you're cross-examining and then your own expert, Dr. Milroy.
Mm-hmm.
And substantially they were in agreement, weren't they?
No, I think that seems to be what Mr. Mahoney says in his submissions, but that's with respect not the case. Dr. Milroy was
Either they were in agreement and this wouldn't matter, or they were in disagreement, but you had the benefit of Dr. Milroy's evidence to place before the jury.
and I take what your lordship is saying, but during the cross-examination of Dr. Obafunwa, which was crucial, one would think, on both occasions, I'm being asked to cross-examine the doctor as best I can on the 12th, which led to some difficulties. Given some more time, you will see on the 18th, go to what happens. Sorry, I could just have one moment. I apologize. Court's indulgence. Is that I continue to cross-examine, as you indicated, based on having had some further time to consult, but it is a piecemeal, completely a piecemeal approach.
And Ms. Mulligan, I have some sympathy with your position, but the reality is that there was very little material from Dr. Obafunwa by the time you started to cross-examine. There was the reference on the last page of the post-mortem report to serrations, which we've seen. He says the serrated appearance of of wounds, and he identifies them 13, 18, and the long arm of 6 will suggest the use of a blade which is serrated with intervals. And then in his notice of additional evidence statement, simply could have been caused by a single weapon having both a serrated and straight sides. So, sorry, carry on.
Sorry, I apologize. In the midst of the examination in chief, a new disc of photos was put in by the prosecution. Not photos we had never had, but photos that the prosecution was not relying upon until that day.
And photographs
so there were new photos
on which Dr. Obafunwa had not opined before.
Yes. So that was being dealt with as best I could in cross. There was further cross on those photos. I agree, after I had some opportunity to speak to Dr. Milroy in Canada and send him the materials and do what we could in the time we had. But it wasn't satisfactory. And at the end of the day, it's not that Dr. Obafunwa came down to the opinion that he said in his statement. He came down to a new opinion. I may take you to that. Moment.
And this was given in chief?
I think it was given almost in re-examination, but if I can have a moment.
If you look at page 13 of the transcript of Obafunwa, he says at line 18, I forgot to mention the fact that when you look closely at the edges of the wound, it shows a serrated appearance. You can make out some spikes, some irregularity, which shows a serrated appearance. And by reason of the fact that he starts saying, I forgot to mention the fact, that might suggest that was the first time it was raised.
Yes, but it goes on.
Well, it depends on which wound he's
Yeah, that was
talking about, because what he'd said in his original report was that the second serrated appearance of wounds 13 and 18 and 16 suggests the use of a blade which is serrated. So
Yeah.
we can't tell whether this is a new wound, which he should have
But
mentioned.
he says at line
Or,
line 15, 16, I want to go back to the first wound.
yes. Yeah.
When you go through the evidence as a whole, you'll find that almost every wound that he is asked to look at, he describes as serrated in evidence.
Whereas in his original report, he identified serrated by reference to the 3 wounds, numbers 13, 18, and the long arm of 6.
Yes.
And 13 is on the left upper limb, 18 is on the left lower limb.
It's really hard to go through his evidence because it wasn't usually responsive to my questions. But if you turn to page 132 of his evidence,
Yes.
you will see how, or maybe 131, I apologize, of Dr. Obafemwa's evidence.
Mhm.
Actually, go back to 130. So I discussed 3 injuries with him. At page 130 at the bottom, I say, okay, so those 3 you are saying give you evidence, proof positive in your mind that it had to be a double-edged serrated knife. I have no reason to doubt my conclusions. Different question, different question.
Sorry, Ms. Martin.
Sorry.
Where are you on 130? Oh, right at the top?
No, right
You
at the
started-
bottom. Right at the bottom. Because I've gone through with him at that point 3 particular injuries. And I say right at the bottom at line 25 of 130, okay, so those 3 you are saying, give your evidence proof positive in your mind that it had to be a double-edged serrated knife. Answer, I have no reason to doubt my conclusions. Different question. Is it your evidence that it had to be this odd knife that you've never seen?
Well, I think it helps though, doesn't it? It helps if we go back to the bottom of 129,
Sure.
which is where he first talks about a double-edged serrated knife. You put to him, you've told me about one injury that you say gives you evidence, proof positive that it was a double-edged serrated knife, that odd type of knife. And he says, yes, that's correct. I've given you an example. So.
And I say, okay, are there others that you have looked at? Because you've had this opportunity to look at all the photos and come to some recently. Are there others that you've looked at recently that indicate to you for sure this odd knife was used? I believe there are 1 or 2 other injuries that I displayed showing serration. And I'm sure when I go into the internal injuries, he hasn't done that yet, we will see. Okay, what organs are they in relation to? The rib. You're saying that's a double-edged serrated knife, serrated on both sides. The rib, we'll see the configuration. Yes. The heart, we'll see the configuration. Okay. So those 3 you're saying, give your evidence, proof positive in your mind that it had to be a double-edged serrated knife.
What's
no
the
reason-
third? Just a minute. What's the third of those? Rib, heart, and
I don't think we get to it.
It's probably
Well,
above. Sorry, it's probably above. If we go back to wound number 6, and I don't know what that was, but if we look
oh yes,
at
injury to the face, which is one of the ones.
128. Yeah, I say I'm going to suggest to you there's no
I'm sorry, I can't hit your fading.
So I suggest there's no evidence. Sorry. I apologize.
Where are you taking us?
Sorry, 128 at line 7. We'll start a little earlier up.
Right.
There were more photographs to be shown by the prosecution, but what I said was, I'm going to suggest to you that there is no evidence from which you would be able to determine that a knife serrated from the tip down both sides and then blunt was actually used in this offense. That is not correct. In fact, I recall when I was demonstrating wound number 6 on the cheek, I demonstrated the serration on both sides. So that had come in chief originally. So your statement is not correct, ma'am. So there's one injury from which you say there's an indication of a double-edged serrated knife from the tip down. That was one of the injuries that I can recall easily. Okay, well, that's what I'm asking you. You're saying it's number 6, the injury that I just gave that as an example. Are there others? When we look at the other injuries, and it's not, I mean, I'm asking open-ended questions here because I don't know what the man is going to say. And I need to find out in order to be able to take some instructions. And this is the wrong place in my respectful submission for me to be doing it. When we look at the other injuries on the inside, I guess we'll be able to decide. No, well, you should know by now. I've not fabricated anything. We are looking at the same photograph of the same case. I know, but you're saying you'll be able to determine it. You're not just determining it on the stand. You know whether there's any other evidence of a double-edged serrated knife right now. Answer, that's right. And I'm suggesting to you that there isn't any. You've said injury number 6, the injury to the face gives you. I just gave that as an example. We can go over the images again. Well, I'm asking you about your opinion now. You've already come to it. You're not just forming it, looking at the photos. Okay. You've told me about one injury that you say gives you evidence, proof positive that it was a double-edged serrated knife, that odd type of knife. That's correct. I've given you an example. Okay. Are there others that you have looked at because you've had this opportunity to look at the photos and come to your opinions recently? And so on. I believe there are 1 or 2 other injuries I displayed showing serration. And I'm sure when I go into the internal injuries, we're already in cross, but he knows he's already going to look at more photos. We will see. Okay, what organs are they in relation to? And then he says the rib. You're saying that's a double-edged serrated knife, serrated on both sides. The rib, we'll see the configuration. We'll see the configuration. So those 3, you are saying give your evidence proof positive in your mind that it had to be a double-edged serrated knife. I have no reason to doubt my conclusions. Different question. Is it your evidence that it had to be this odd knife that you've never seen, the double-edged serrated, double serrated edges that caused the 3 injuries? That's my conclusion. And that conclusion you stated for the first time from that witness stand, right? Now, yes, I did. Don't forget, I did not show the internal injuries when I was there the first time. Yes. If I'd shown the injuries, I would have made the same categorical statement now. Well, except that your opinion would remain the same no matter what photographs you showed, right? Your opinion doesn't change. My opinion does not change, but this is the first time. But however, no, see, I recall the last time you said I had no evidence of serration. And I said, question, double serration. Serration of the blade. And I said, because I was not showing the internal injuries, there are certain things I did not mention. And you were very categorical that I didn't have any evidence. And then we get into discussion about there being a difference between evidence and being positive of something. He says, if I have evidence, I have no other conclusion but to be positive about it. I say, well, you weren't positive on February 9th, as to, you said it was only possible that a serrated and straight edged blade could have been used. That come again, that it was only possible that one knife with a serrated and straight edged blade could have been used. That's correct. Now, don't forget that you have serration does not mean that you don't have a straight component to it. The same knife can have serration and a sharp component that is not serrated. So again, I don't want to be taken out of context. So we go through what he said. And he says nothing has changed. He says at line 12, you can have serration on both sides with a sharp straight component all in the same wound. I said it's a function of the configuration of the blade. I've not said anything different. I think this should be a question. Are you saying today from that stand that the injuries in this case were caused by a double-edged, both sides of the knife serrated from the tip down, and then blunt edge to the handle? Are you saying that that must have been the knife, was the knife that caused these injuries? I repeat, it might, with the appropriate configurations of serration, even on both sides, a sharp component and a base with some projection outwards is capable of producing the same injuries that we have observed. I have not said anything different. So I tried a different way at the bottom of page 134. The best you can say, the most you can say scientifically is that one knife was used, or more than one knife. Full stop for a moment. Is that fair? One knife with the appropriate configurations that I've mentioned is capable of producing the injuries. And is it possible that two knives could have produced the injuries with the appropriate configurations? Two knives would not produce. You're not going to use two knives to stab somebody at the same time. So he's drawing some, I guess, logical conclusions from what he believes to be the way I don't know what he doesn't think it's logical to use two knives to stab somebody at the same time. The witness, excuse me, you hold two knives, two blades, two ends of it. You're going to have two different pointed edges when they're entering, where they're entering the body. You're going to have two different blades entering the body. Yes. Why are you talking about two weapons being used? Probably one fell and used the other one to produce the injuries on the person. That's a different thing. Is that you have a theory about what happened at the scene? No, I'm only going by what you said. In other words, I don't agree with you. That's what I'm trying to say, that the hypothesis you're trying to put on the table does not fit in. And then we get in discussion of whether he was at the scene and all of that. I think it comes back down to double-edged serrated being his, well, Mr. Richardson cross-examines him about being a hired gun. And then in re-examination, we see it again. Yes, he's asked about the sketches. This is at page 164.
All right.
He's asked about the sketches by Mr. Mahoney. And I think the four defense lawyers met me in the side room there, asked me questions about what I meant by a serrated weapon and whether serration could be on one side or both sides. And is it possible to have sharp components to it? And what I meant by a blunt margin or blunt edge. Sorry, a blunt edge. In the course of explaining this, I asked that if I could make a sketch explaining the point I was making. But before doing this, I said this is just an explanation of what is meant by serration on one side or both sides, the blunting, and that it has nothing to do with the weapon that was used. So I made a sketch of a blade with serration on one side, a blade with serration on both sides, additional straight angles and terminal parts of the blades that could be responsible for blunting. That's how that came about. And then Mr. Mahoney says, okay, now it was put to you that by Ms. Mulligan, there's nothing you've said or demonstrated that supports the theory that there was a double-edged serrated weapon used. And you said that you can establish that from images. I think you said the gory images you were not allowed to show. And at that point in re-examination, he is shown, if you do at the bottom of 166, he is shown photographs to demonstrate what he says are double serrated edges. And that goes on for several pages in re-examination. And these are the photographs that Dr. Obafunwa decided he needed to show this new opinion, but the Crown had not been relying on earlier. And he gives a great deal of evidence about them. I'll go through it. I mean, it's quite complex evidence.
I mean, did the jury have these gory photographs? Well, was the jury looking at these gory photographs by this time?
Yes. They were shown to the jury during the re-examination.
Well,
And there were some they saw in chief, but we tried to limit it, obviously, to what was necessary. The actual gory photos of the body parts, the wounds being stretched and that sort of thing, we tried not to. Particularly I think the one of the face where the skin is peeled back, but the jury ended up seeing all of it. Essentially, not every single picture, but quite a few of them, because Dr. Obafunwa wanted to use that. But what happens there is, because the court decided that we should soldier on, essentially, and if there was something that couldn't be dealt with during Dr. Obafunwa's evidence, then I could call my own expert. That the re-examination was done introducing all of this new evidence, which I would not have been in position to deal with. I mean, it was all new. You'll see he describes zigzag patterns and serrated weapons, things that were not in his report on a number of images. And then I was left to try and deal with it by calling my own expert. All of this happening mid-trial. I mean, you can read for yourselves the evidence of Dr. Obafunwa. I would submit it's not very satisfactory from a defense perspective. I don't think it was the most sterling cross-examination I certainly have ever done, or the most knowledgeable one, and it should have been. It should have been. But there's a reason why we require that expert reports be given sufficiently ahead of a trial, especially this kind of expert, so that defense counsel and defense experts have sufficient time to consider it, to think about it, to look at it in relation to the rest of the case.
That's not so much the problem as the fact that the report which you got the day before was basically a two-liner, and it was the evidence in chief that went into matters in great detail which had not been done before.
Yes, the evidence in chief, to some extent, the cross-examination brought out some of that, and then the re-examination brought out more. I mean, a lot of what he said, he was saying for the first time on that witness stand, as far as we knew. And I assume that if he had said most of that to the prosecution, it would have been reduced to writing. So as far as we knew, it was being said for the first time on the witness stand. Although I do think that, I do recall Mr. Mahoney making the submission that not everything gets put into a expert report. And he can refer to items outside of that to explain his conclusions. But I think it went well beyond that in my respectful submission. So the court was faced with, when this all came up in my submission, those options, either denying Dr. Obafunwa the opportunity to give his further opinions, his newer opinions, and carry on with the trial, in fairness to Mr. Rogers, or mistrying the matter in order to give sufficient time for proper consideration of all of this new stuff, although it would only be after evidence in chief, as Lord Justice pointed out, Justice Bell, that we would actually fully, or at least almost fully, have his new opinions. But certainly at that point, I raised the issue, and the decision was made that we should soldier on and do the best we can. And so we did. That's the ruling of the court. That's the ruling of the court. And time was given for me to get my expert and to speak to my expert sometime. But in my respectful submission, as you can see, as the evidence developed, it's clearly not satisfactory. And one of the first two options should have been granted: either exclude that new opinion or the new opinions and require him to stick to his autopsy report and perhaps the opinion stated in his statement of February 9th, or mistry the case and give the defense a proper opportunity. But neither of those things happened. At the end of the day, he does say that in his view, it's a knife with double serrated edges. That is different from the opinion of Dr. Milroy, who said that he saw no evidence of that. He couldn't rule anything out. Nobody can, he seemed to suggest that nobody can in cases like this, but he saw no evidence of a double serrated knife. There was evidence of a serrated knife on one side, perhaps, but not of a double. So they had opposing opinions. There was shown some of the same photographs where Dr. Milroy could not see evidence of a double serration, but Dr. Obafunwa had opined that there was. So we were faced not with the same opinion at the end of the day, but with two very different opinions. Yes, at the end of the day, they both said they couldn't say whether it was one knife or more than one knife. They couldn't rule out any particular configuration. They both could say that at least one weapon would have some serration on it, but certainly it was not Dr. Milroy's opinion that there was any evidence of a double serrated knife from the tip down. Both he and Dr. Obafunwa were very clear that they'd never seen such a knife, never come across one in their work, that it would be a very unusual knife indeed to be configured that way. And there were pictures put in, diagrams of knives and the normal configurations, etc. But the import of this evidence was, we had what I have submitted was a very weak, vague, and inherently unreliable confession evidence of Ms. Card, who gave this description of this knife, and Dr. Obafunwa at the 11th hour supported that description, supported her evidence at the 11th hour that it could have been, and likely was, a double serrated knife with serrations close to the tip, exactly as she had described. He maintained he was never told about her description, although an expert could certainly be asked, could a knife like this make the injuries by the prosecution? But he maintained he was never asked that. He just, never having seen such a knife, never having been described such a knife, he's come up with it in his mind that would have to be the kind of knife. Astonishing, really. With my,
that's evidence.
Yeah, it is now. I mean, was then as he was on the stand, that certainly became his evidence. But it certainly was not foreshadowed in anything prior to him taking the stand. And it was, in my respectful submission, it would be hard not to imagine that his evidence became more and more tailored and consistent with that of Katrina Card's description. How that happened, I don't know. I don't know whether he gleaned the importance of that description from something, whether he was told about, I don't know. He says no. He says he wasn't told. But it is impossible. It is very difficult to believe that he didn't have any information, which he would have been entitled to as an expert, but that he didn't have any information about her description, but yet conjured up a knife that he had never come across in his entire many years of doing this work. But that whole area in my submission was most unfair to Mr. Rogers. It was one of the few bits of evidence, and given as an expert, that might tend to support something that Ms. Card had said, when all the rest seemed to suggest that she was not telling the truth or was inaccurate. This might tend to support her. I've set out in my submissions, almost all of these submissions that I've just made, both at beginning at page 7, running through to page 10, and then again going into some different detail about it at page 22.
In paragraph 18 on page 9, you say in the second sentence, his final conclusion, not contained in his report and not offered until he was in the witness stand, that a double serrated edge knife looking exactly like the one described by Miss Card could have caused all of the injuries, smelled of witness training. Is that actually what he said? He certainly said that a double serrated edge knife caused some of the injuries. But I haven't picked up that he said it caused all of them. Indeed, that
He
would
said
be
it
inconsistent.
could have. He said it could have caused all of the injuries. Let me just find that. Because he, remember, he maintained it was one weapon. It would make no sense for it to be two weapons. And that was that whole area that we went through. It made no sense for him to be two weapons. It was one weapon that caused the injuries.
Yes, but that begs the question as to whether that weapon.
Yeah.
Whether all of the
If I
injuries
can just
were.
come to it. Well, beginning, I mean, I put it to him, I suggest to him that there's nothing to support.
Which page are you on, Miss Bell?
Sorry, this is at 77 at the bottom. It evolves. So we begin with at line 17. I'm going to suggest you, having gone through all the photos, I've looked at your report, I've heard your evidence. I'm going to suggest to you there's nothing that you've said or demonstrated that would support the theory that the knife used in this case had double serrated edges, serrated both edges on both sides of the knife from the tip. Answer, because I've not been allowed to show the details of the internal injuries. If anybody is in doubt, I can answer it, would show and see the serrations on both sides of the internal organs. So your answer to my question is you're saying, yes, there's positive evidence that the knife that made these injuries to Mr. Gibbings was serrated on both sides from the tip. That's correct. I can establish that by showing the images. And I said, have you ever come across such a knife? Oh yes, you have multitudes of knives that show serration on both sides from the tip, serrations on both sides evenly from the tip. You can have a knife that shows serrations on both sides. I said, that's not my question. Eventually on page 79, he says, I've not come across them. The fact that I've not come across it does not mean it doesn't exist.
Would you excuse me for a moment? I must answer something which is a point. Sorry about that. Yes.
And then,
Ms.
But I don't
Mulligan, I
think
just,
sorry.
your client has left the room, Ms. Mulligan. I'm not sure
Yeah.
if you want to continue.
Oh,
When the president left momentarily, your client fled, taking the opportunity, I think.
it's,
I'm sorry, I was on an errand of mercy. My wife was locked out of the front door.
oh no. Or maybe I'll take this opportunity to find.
Yes.
Okay, Mr. Rogers is back with us.
Thank you.
Right.
All right.
But I don't, from the passages that you've been reading to us, for instance, where he said that it was correct that there was positive evidence that the knife that made those injuries was serrated on both sides from the tip. I don't take that to be saying, and all of the injuries were caused by the serrated bit. Indeed, that's I think the opposite of what, if we could go to his original autopsy report at page 269.
Could I just, before we go to that, Sir Christopher, point out at 78, when the question, line 4, Ms. So your answer to my question is you're saying, yes, there is positive evidence that the knife that made these injuries to Mr. Gibbons was serrated on both sides from the tip. Answer, that's correct. So maybe these injuries has been equated to all of the injuries.
I did, and that was my understanding, and I'm just trying to find a more clear passage, but I did ask him, just to go back to a point raised earlier about the autopsy report at page 16. I asked him about the 3 that he talked about. I'm asking about what's in your report. Do you see anything there about serrated, ragged, jagged, rough, uneven, irregular edge? I didn't put it there, no, but that does not mean it's not there because I showed the photographs.
Which page are you looking at now?
This is page 57 of his evidence. 57?
Yeah.
I had started at the top of the page saying there's only one where you note there's a slightly ragged edge on the part of the limb. If you look at wound number 3, and he says in the middle of the page, I described as 3-shaped, and I thought I demonstrated that could also pass for a serrated edge. And I'm asking him about that, and he says, well, he didn't put it in his report, but now he can show it on his photographs. But there's
Which report are we referring to?
That was the autopsy report. The autopsy report, the actual postmortem. And he's cross-examined about that a bit, that he doesn't put, he only uses the word in one instance. But I think there is something more concrete to answer your question. I hope there is.
Well, can we just look at what I was going to was his autopsy report.
Mhm.
He sets out the injuries numerically at page 261. And then at the top of 269 says the serrated appearance of wounds 13, which is the left upper limb, 18, the left lower limb, and the long arm of 6, which is the wound on the left cheek at the face, suggests the use of a blade which is serrated. So he refers to a serrated blade causing or suggesting, is the suggested cause of the appearance of 3 of the wounds, though he doesn't use the expression double serrated. And then he says the fact that wounds 9, 11, and 22 show, and 9 is the left chest, 11 is more of the left chest, and well, I don't know what 22 is.
It's on page 263. It's the internal injury.
Oh, I see. I'm so sorry. Yes. The internal right shows a single blunt margin, which are medially directed, will suggest a single-edged blade as having been used. I'm afraid I think counsel had some difficulty in understanding what that meant. But what does it mean? A single blunt margin medially directed?
Yeah. I'm not positive what he meant by it.
No. Well, it's something which suggests a single-edged blade was used, which would appear to be an incision which shows no signs of serration.
Yes.
But if you start,
Which is what we thought.
well, yes, I'm not an expert, sir, but if you start with a blade which is serrated on both edges from the tip of the blade towards the handle, I don't quite understand, but towards the as you get closer to the handle, isn't serrated on either the top or the bottom of the blade. I have a little difficulty in seeing how you would discover that there was a single blunt margin, if that means that which you would see if the knife didn't have any serrations. I mean, if I stick a knife into your chest, which has serrations at the top and the bottom, and it doesn't get to the part of the knife that doesn't have serrations until 4 inches have gone in, I don't quite know how the single blunt margin displays itself. But
Yes, and his only answer to that seemed to be that if it had gone in to the point of the blunt end or the guard, then it may change the appearance of it and make it appear to be blunt. But it could still be a serrated knife, is what he was saying.
Yes, because it's serrated at the front and blunt at the nearer the handle. Okay. Thank you.
So yes, I guess the clearest question asked about that being serrated on both sides and his position that was the weapon is on 77 and 78 in my questions to him.
Okay.
And I should have been more clear in my question, because at line 17, I say, having gone through all the photos, looked at your report and heard your evidence, I'm going to suggest to you there's nothing that you have said or demonstrated that would support the theory that the knife used in this case had double serrated edges from the tip. And he responds that that's because he wasn't allowed to show the details of the internal injuries he would show the serrations on both sides of the internal injuries. And I say, so your answer to my question is you're saying there is positive evidence that the knife that made these injuries to Mr. Gibbings, and that was a general reference to the injuries, was serrated on both sides from the tip. That's correct. I can establish that by showing the images.
Yes.
So I thought that Mr. Mahoney had come back to it, but I'm not seeing it again. So I could be wrong. In re-examination. But I don't see it at the moment, so I must have misrecalled that. It's just discussion about the sketch of the blade. Oh, he seems to backtrack actually in re-examination. He says at page 165, line 15, he's talking about the sketch. So I made a sketch of a blade with serration on one side, a blade with serration on both sides. Is an internal part that could be responsible for blunting. Okay, yes, that's how that came about. That was it. Okay, now it was put to you that by Ms. Mulligan that there is nothing you have said or demonstrated that supports the theory that there was a double-edged serrated weapon that was used. And you said that you can establish that from the images. I think you said the gory images that you were not allowed for you to show, that were not allowed for you to show. I recall saying at least one of the wounds, I mentioned wound number 6 showed serration on both sides. And I did mention that if we go in to look at the internal injuries, we'll find further evidence of serration. So that seems to take it back somewhat, but I don't know how far. Because then he goes through the new photos and finds serration on both edges of almost all of them. Or at least he seems to say that. So.
No. Well, I think he said what he said before. The injury to the face, number 6, and to the rib and to the heart show that there was serration.
But he goes further now, says double serration to the tip of the knife. So that's another step beyond what he had ever said before or described before, including in his statement of February 9th, where he had said serrated on one side. Possibly.
Well, he hadn't said, he'd said serrated without saying whether it was single or double.
I think in the, well, yeah, in his original report, you're right. That's true, but in his statement of February 9th, he only goes so far as to say that it is possible that a single weapon having both a serrated and straight sides could have produced the injuries seen. We took that to mean a single weapon with a straight side and a serrated side. But apparently that wasn't necessarily what he meant.
Oh, I see. Yes, because that's ambiguous, isn't it? Because a single weapon with serrated and straight sides could mean a weapon which on the top is straight and at the bottom is serrated, or the other way around. Or it could mean a weapon that is serrated on both the top and the bottom until halfway towards the handle, and then is non-serrated from halfway up the blade towards the handle.
Yeah, which is when we got the diagram on 478, which showed those two different possibilities, I guess, that he drew for us.
Yeah.
And that's when we said, oh, wait a minute. A double serrated edge right to the tip, just like Ms. Card described, we're going to need, this is new.
Yeah. Just help me on this. Before the professor went into the witness box, the defense obviously had the autopsy reports, which we can see.
Yes.
And it had, you say rightly, late in the day, the witness of the statement of the dated the 9th of February, received on the 20th of February, 10th of February. And you had some pictures of wounds, but did you have anything else?
Did we have anything else?
From Professor Obafunwa?
No, we didn't. We did get on February 10th. If you turn to tab 12 of my friends, Mr. Mahoney's materials.
Yes.
The further photos that had not been, I guess the photos that they were hoping to rely upon after having adjourned on February 10th and having met with Dr. Obafunwa. The photos being proposed are set out there and they're by number, so that doesn't help you much, but there were a great many of them.
And presumably, Miss Mulligan, these were the photos that Mr. Mahoney took the doctor to in re-examination.
I believe so. I just want to make sure of that before because we had discussed photos at some point prior.
But as I understand it, you had received these photos before, but were not given to understand before this email that they were going to be relied on in evidence. Is that right?
That's my recollection, that we had the full photographs from the autopsy. But did not understand that all those were going to be relied upon. And then Dr. Obafunwa, as I recall it, wanted to see some other photographs. My expert ultimately said, well, there's at least 2 or 3 that you should show them. So a further disc was created. At least that's my recollection. I'm trying to look at the emails now. Yeah. The email that I wrote on tab 13 having been instructed to go away and do the best I can, I did. And I indicated that there were some photographs that we would want that were not contained in the Crown's proposed disc. And then I would make every effort to be able to proceed on the 12th, which I did.
Yeah. Yes.
So I think Ms. Mahoney takes from that I felt comfortable doing it. I did not feel comfortable. That's why I brought the application for the mistrial, or that he not be permitted to give the evidence. But having been instructed to do it, of course, we do what we are instructed to do.
So it worked. Right.
Okay.
But
in my respectful submission, it ought not to have happened that way. It ought not to have been permitted. And if the Crown was seriously seeking to rely on this evidence, the defense ought to have been given a proper opportunity. The matter ought to have been mistried. It is not satisfactory to deal with this kind of evidence mid-trial. We're not just dealing with this one expert. We're dealing with a whole trial and upcoming witnesses and legal arguments and closings, and it is just not the time to be trying
Right.
evidence that is evolving, expert evidence. Where are we at for time wise? I'm not sure when the court wanted to break.
I think we probably ought to break now. Subject to this, what have we got left?
I know I've been bouncing around a bit and I do apologize, but we need to look at, now that we have at least the note of the dismissal of the stay application, we need to look at, some of it I've covered, so I won't go back to it, the evidence of Card and Foley, but we need to look at the missing footwear evidence.
Yeah.
I've covered mostly the evidence of Dr. Obafunwa, so I don't need to go back to that. And then other lost evidence, which would include the search warrants and
Okay.
notes and statement of Mr. Rogers, all those things.
So how long do you think we're
But I
likely to be so far as you're concerned?
I don't think it'll be that long. Just checking to see if I've got. Shouldn't be that long. I will have a point to make about my friend's suggestion that even if there were errors, there's no miscarriage of justice under the unreasonable verdict kind of ground, but also in response to that. So I suspect I will be maybe an hour, possibly an hour and a half.
Okay, thank you very much. Where we will adjourn till 9 o'clock tomorrow Bermuda time, 1 o'clock tomorrow UK time. Thank you very much.
Thank you.
Thank you.